as we gather today to deliberate on a matter of grave national importance, the protection of our republic, our people, and our democratic institutions. Grant us, legislators and all present, the clarity of mind to discern what is just, the courage to confront emerging threats to our sovereignty, and the humility to listen to differing views in the spirit of truth and respect. As we consider measures to strengthen our laws and espionage, may we be ever meaningful that the security of the state must always stand in the harmony with the freedoms enshrined in our Constitution. Guide us to craft legislation that safeguards our nation without fears, protects our people without prejudice, and upholds the rules of laws without compromise. May our deliberation to guide not by partisan interest but by genuine love of country, not by haste but by wisdom, and not by suspicion but by fidelity to justice and accountability. Bless our nation, the Philippines, protect those who serve in defense of our freedom, and grant that the laws we shape today may secure a future that is safe, just, and worthy of the trust of our people. All this we ask the gratitude and hope. Amen. In the name of the Father, Spirit. Amen.
Again, first, I would like to welcome everyone to today's meeting. And now I will recognize... Minutes muna? Okay. Let us move on to the minutes of the previous meetings. May I solicit a motion to approve said minutes?
Madam Chair, I move to dispense with the reading and approval of the December 1 and 4, 2025 minutes of the subcommittee meetings.
There's a motion and it has been
Seconded.
seconded. So the minutes of the meeting held on December 1 and December 4 are now approved. Next, we go to the recognition of members. First, I would like to recognize Representative Nathaniel M. Odogado of One Tahanon Party List, who serves as my co-chair in this meeting. Good morning, co-chair. Next, I will recognize Representatives Rufus B. Rodriguez of 2nd District of Cagayan de Oro City.
Present.
Representative Eulogio R. Rodriguez of the Lone District of Catanduanes. Representative Antonino B. Roman III of the 1st District of Bataan. Representative Richard I. Gomez of the 4th District of Leyte. Representative Arnan C. Panaligan of the 1st District of Oriental Mindoro. And Representative Congressman Jose Manuel Tadeo Chel Diokno of the Akbayan Party List. Next, we go to the recognition of our resource persons. COMSEC, please recognize our resource persons today.
Thank you, Madam Chair. Good morning, everyone. For today's subcommittee meeting, we have the following resource persons. From the Department of Justice, we have State Counsel Lailani Fajardo Aspiras.
Can you raise your hand and say present? Yeah. From DOJ, right?
From the Department of Justice.
Yes,
Good morning
thank you.
po.
Yeah.
From the National Bureau of Investigation, we have NCR Regional Director Ferdinand Lavin. Good morning, sir.
Good morning, present.
Mimaropa Regional Director Jeremy C. Loto.
Morning, ma'am. Present po.
Mr. Kennedy Del Rosario, LLU staff. From the NSC, National Security Council, we have Director Monico Batle. Have a seat, sir.
Representing NSC, right?
Also from NSC, Attorney Camille Angelica Gonzalez.
Present po.
National Security Specialist 2 to Mary Grace Fabillar. Thank you, ma'am. From the Armed Forces of the Philippines, we have Lieutenant Colonel Lex Michelle Dapanas Jags. Morning, sir. From the Department of Information, Communications, and Technology, we have Director Alvin Navarro. Good afternoon, sir. Good morning. From the Department of National Defense, we have Attorney Leonardo V. Calderon III, Director for.
Good morning, President.
Good morning, sir. From the Philippine National Police, we have Police Colonel Dominador Matalang, Directorate for Intelligence. Good morning, sir. We have Police Lieutenant Colonel Ivan Abesa of the PNP CIDG. Good morning, sir. Philippine Coast Guard. Yes, sir.
Good morning, Your Honors. Lieutenant Commander Ramos from the Coast Guard.
That will be all, Madam Chair. Thank you.
Has everybody been called in those seated in our farm? Because others have not been called. Joaquin and Arcelias.
May Arcelias from the National Intelligence Coordinating Agency.
Nika also.
Good morning.
Good morning, Mr. Chair. Attorney Salmo De Joaquin from CICC, Mr. Chair. CICC.
Okay, thank you very much, everyone. So let me proceed to my brief recap of what transpired in our last meeting. Good morning, ladies and gentlemen. Last meeting, it was established that House Bills number 6177 and 6183 proposed to add, whether in times of peace or in times of war, to Article 117 of the Revised Penal Code to clarify its applicability. House Bill number 6183 expands the definition of espionage to include modern threats, covers government officials, and links espionage to anti-money laundering laws. The other bills were referenced, including House Bill 2793 of Representative Benitez, which addresses foreign interference, a broader concept than traditional espionage. We discussed that our laws are really outdated. For everyone's notation, our laws on espionage are as follows. Under Article 117 of the Revised Penal Code, there are only two modes of commission of espionage, which is the first, obtaining confidential information relative to defense, and second, disclosing its contents to a foreign nation, briefly. We also have Commonwealth Act number 616, which, in brief, defines espionage as unlawfully obtaining information relative to national defense, unlawful disclosing of information, disloyal acts in times of peace, disloyal acts in times of war, conspiracy to violate the preceding sections, harboring and concealing violators, photographing, reproducing without permission, destroying war material, making war material in defective manner, injuring national defense material, and making these in a defective manner. So we said that these are obsolete and they only cover physical intrusion into military sites and disclosure by public officials, lacking provisions, obviously, for cyber espionage or non-military threats. We were able to decide to legislate the expansion of espionage and leave the matters of foreign interference to the Committee on National Defense and Security. We also deliberated on modernizing the definitions of cyber espionage, as the current laws do not cover hacking, drones, AI, or remote data theft. Broader scope of espionage that may now include national security, not just national defense, economic security, and including juridical persons as liable entities. We also mentioned the proposed regulation and licensure of surveillance devices. On the other hand, some civil liberties concerned were raised by Representative Biokno on the overly broad definitions that could threaten journalists, researchers, whistleblowers, and ordinary citizens. He urged to retain the narrow definition, adding safeguards for public interest disclosures and ensuring judicial oversight. In sum, the following are the following list of position of the different agencies. For the DOJ, they support the comprehensive updates, including foreign interference. For the AFP, they recommend covering all national security domains, political, economic, social, technological, and military. For the PNP and the NBI, they stress the need to include cyber methods, regulate surveillance, and clarify liability for juridical persons. For the NICA and the NSC, they preferred separate bills for espionage and foreign interference, and they support modernization. For the Coast Guard, they request inclusion of maritime domains and law enforcement agencies and in the definition. The following were agreed upon. Amend Article 117 to add whether in times of peace or war, include modern means of espionage, and extend liability to juridical persons. Next, we consider a separate espionage law, update Commonwealth Act number 616 to comprehensively address modern threats. Finally, we tackle foreign interference separately, and this will be tackled by the Committee on National Defense and Security. Last meeting, the resource persons committed to submit position papers within 10 days. Only the PNP position paper was received by the committee. We have prepared a substitute bill which was distributed to the members and to our guests today. We solicit your comments and recommendations, suggestions, and I hope that we will all have a productive meeting ahead of us. Thank you very much. Kong Odocado, do you have a speech today? Okay.
Madam Chair, good morning. Good
Yes,
morning
good
to
morning,
our
Kong.
distinguished colleagues and our resource persons. What I have is only the bill, the consolidated bill on expanding the coverage of espionage law. I don't have here the amendment to the revised penal code. We have earlier agreed that there will be 3 bills. Revised penal code amendment, and then we have the espionage law, and then the third goes to the Committee on National Defense. May I know where because we'd like to tackle first the revision. It's more simple, the revision of the revised penal code.
Chair Rufus, right now what we intend to do is, since we have a draft espionage bill, which is the one that was distributed, the general sentiment last time was that the revised penal code will be amended and it will make reference to the provisions of the draft espionage law.
We could not make reference because the revised penal code is mala in se. In other words, it is different from the espionage law, which is mala prohibita. The violators will be subjected to 2 cases and 2 penalties. And that's why we would like that the revised penal code be amended to say in times of war and peace, as requested by Secretary Gibo Teodoro. I had a conversation with him. And then secondly, to include cybercrime. But it will be short, and this will be mala in se. And so then we proceed with the espionage law. And we hope, the espionage law, I hope it will not repeal the revised penal code, because certainly that will give a signal to our Chinese bully that we are removing from Mala Inse issues of national security. So, Madam Chair, I would agree that we first have the expanded coverage spinal law, we have it here, and we can discuss that. But without prejudice to the revised penal code amendment. Let me state, Madam Chair, I have filed these bills in the past two Congresses. And it becomes more important now because the government is granting Chinese citizens to come here without any visa-free. And that will open the doors for espionage. They can easily come here 14 days. I objected to that, but because we need revenues, which to me, between security and revenue, always the priority is security of our national territory, Article 1 of the Constitution. And so therefore, Madam Chair, we will be discussing and expanding the coverage of spionage law. And do we have the assurance that without prejudice to the revised penal code, so that it will be mala in se?
Yes, Chair Rufus, you have the assurance that we will be tackling that. Chair Rufus, actually, for the record and for everyone's information, also under the revision, the Committee on the Revision of Laws, we are also the chair of the subcommittee which is tackling the revision of the criminal code. And in fact, one of the proposals there is to remove the distinction between mala in se and mala prohibita. So that we may proceed with the deliberations first on the espionage bill, and then we will tackle the revision or the amendment of the revised penal code provision, which we will also tackle in the other subcommittee.
Thank you. It is true that we have filed two bills revising the revised penal code, which was approved in December 1930 and became effective on January 1, 1932. Very old law, almost 100 years, and it's now in the committee. There are now two versions, the Code of Crimes and now the DOJ, Code of Crimes from the UP Law Center, now the DOJ with their Criminal Code of the Philippines, and we're going to do that. But it will take time because that is already some sort of a updating and the start of the codification of all criminal laws of this country. So I suggest after we finish the coverage of espionage law, we go to the revised penal code to be able to really make sure that those who are bullying us will know that those committing these crimes will be facing two cases. And then we will decide in the Criminal Code of the Philippines whether we will distinguish between mala prohibita and mala in se. And of course, in the codification, it all becomes mala prohibita. So therefore, Madam Chair, we can proceed with the coverage of the, expanding the coverage of the espionage law. Thank you, Madam Chair.
Thank you as usual, Chair Rufus, and you have my assurance that we will be tackling that since both of us are the proponents of the bills revising the code, the revised penal code. I would like to recognize Representative Gerald Cloyd Alexis V. Galang of the 2nd District of Valenzuela. Good morning, Kong Gerald. Now, let us proceed with the draft espionage law. We have an act expanding the coverage of espionage law, which has been distributed to you. And I propose to begin with Section 5, which is the definition of espionage. The previous sections would be the declaration of policy, the definition of terms. So I think we can tackle those after we discuss the more important provisions of the bill. So we will go through the bill line by line or section by section. And to shorten proceedings, I will solicit the comments of our House members, next our resource persons. So Section 5 on espionage, any House member may comment. Yes, Kong Panaligan.
I am proposing that we reformat Section 5 for a
Okay.
better presentation. We can put, for example, instead of several paragraphs here, we can number it or put ABC so that we can be more precise in the definition of the specific acts of espionage. No?
Okay.
So we can, I suggest that we come up with a new format for Section 5. That's Section 5. Any person who commits the following acts shall be liable for the crime of espionage. A, deals with classified matters with authority through physical, electronic, cyber, or any other means, etc. B, dealing with a classified matter shall mean, that's a part also of paragraph A. Then we have letter B, accesses any such sketch, drawing, map, layout, blueprint, graphical or multimedia representation of or any classified matter on critical infrastructure, national defense, assets, national security facilities, etc. Then letter C, I propose to insert a paragraph: without authority enters or aids or induces another to enter a warship, fort, or naval or military establishment, reservation, facility, camp or installation, or facilities of the Philippine National Police and other law enforcement agencies, etc. To include the other civilian law enforcement agencies, not just facilities of the AFP. No? And then another, that's for Section 5, Madam Chair. Anyway, I can furnish the
Yes.
COMSEC with the
your
exact format. No?
Yes.
I just suggest that we just divide the paragraphs. We put letters like ABC
Yes.
for clarity.
Okay. We will do that, Kong Arnan. Thank you for
Madam Chair.
your suggestions. Yes, Co-Chair.
Thank you, Madam Chair. Is the proponent willing to yield to some suggestions, Madam Chair?
Yes, of course.
My
Thank you,
pleasure,
Madam
Madam Chair.
Chair. Thank you, sir. Sir, because in paragraph B, access is already mentioned, and I think entry will be subsumed, especially to those areas mentioned earlier by the good proponent. Although we have mentioned prohibited place, national defense assets, is the proponent willing to yield to insert his suggestion to paragraph B so that the paragraph will be just one letter?
Paragraph B of Section 5. Okay, 1, 2.
Subject to styles and amendment, Madam
Subject
Chair.
to style, yes. I'm willing to accommodate that suggestion, Madam Chair.
Thank you, good sir.
Okay, thank
no
you.
more questions, Madam Chair.
Thank you. We will incorporate all of your suggestions. Any House member with comments? Yes, Chair Rufus?
It's already sufficient, but we could also get the advisement of Congressman Arnan Panaligan, but it's already very clear. And to me, it's a very big improvement of the previous one. So Section 5, I would move for its approval.
Madam Chair,
Subject to
Yes,
amendments.
thank you.
yes, Kong Diokno. Good morning.
May I just reiterate for the record my reservations about the definition and my suggestion that we retain with some modifications the original definition. First of all, I agree that we should add in times of peace so that the offense will not only cover time of war, but in terms of the rather than using classified matters, my suggestion is that we retain the original wording of the law, which is on matters of a confidential nature. Of course, I would yield to the sentiments of the majority here. I just want to place my reservations on record. Thank you.
Thank you, Kong Diokno. Can I solicit comments from the different agencies on Kong Diokno's suggestion?
Clarify, Madam Chair, the suggestion is on page 6,
Yeah.
possession of a classified matter. It is now really the choice between classified matter or confidential in nature. That is what Congressman Diokno would like to say, that he would like that instead of classified matter, it will be of a confidential nature. So
As
maybe here,
originally worded.
right, can we hear, Madam Chair?
Can we start with the...
Madam Chair,
Yes.
before we proceed to the resource person, I'd like to be enlightened on the reason why, from Kong Chel Diokno, what's the distinction between of a confidential nature and classified nature, and the nature of his concern?
Yes, Kong Diokno, please respond.
Thank you, Madam Chair. Thank you, Congressman. The concern I have with the proposed definition on classified matter is first that it does provide a lot of leeway to the government or administrator of critical infrastructures. Because if we look at the definition, it states classified matter refers to information or materials classified as top secret, secret, confidential, and restricted in whatever nature or form, which I'm fine with that part, but it says that the government or administrator of critical infrastructure deemed sensitive and requires protection from unauthorized disclosure. My concern here is that it may give too much leeway to the persons, the officials involved, without any legislative guidance as to what would be sensitive and what would require protection from unauthorized disclosure. Unlike the term confidential nature, which I think already has at least some jurisprudential support in terms of what it means. Thank you, Madam Chair.
Can we get the comments of the different resource persons? First, I'll start with the DOJ.
Thank you, Madam Chair. For the DOJ, in our draft comment, we have written that the definition of classified matter should be stated clearly so as to avoid vagueness and overbreadth. If we will adopt, with all due respect, the recommendation of Congressman Chel Diokno, I think we could harmonize it, and if we could just make the definition of classified matter, we could clarify the definition of classified matter. We could put clear definitions on it so as to avoid overbreadth. It could address the concern of Congressman Chel Diokno. With all due respect, thank you, Madam Chair.
We have a definition of classified matter under Section 3, which is classified matters refers to information or materials classified as top secret, secret, confidential, and restricted in whatever nature or form that the government or administrator of critical infrastructures deemed sensitive and requires protection from unauthorized disclosure. It includes everything classified under any issuance or legislation concerning the security classification of matters and information. Is this something that is for the different resource persons, something that is too general, or
Madam
Or
Chair,
is-
just to guide the resource persons, in the agencies, you have a definitive meaning of classified. Is that correct? There is, when it is classified, it's not supposed to be open to the public. Is that correct, that you have in all the agencies, NICA, Armed Forces, Police, Coast Guard, pag classified, there is really already a clear-cut definition of what it is in your agencies. Is that what is the status now? Can we hear the Armed Forces? You have classification, and what is classified matters exactly from the Armed Forces?
Sir, on the system of classification of documents, our classification is governed on the IRR, AP Regulations 200-014, dated 2014. So in the classification of documents, we subdivided into 4: the secret, top secret, secret, confidential, and restricted. And these are defined kung ano yung mga documents that are considered as such. And also, in the possession, in the theory of classification, we are compartmentalized. Not all personnel from the AP are authorized to handle secrets or top secrets, subject to clearance system, as well as the disclosure of these documents, sir. So this IRR is also based on an executive order basing on the classification of documents.
A query, again, secret, top secret, classified, and restricted.
Yes, sir. Top secret, secret, confidential, and restricted.
Restricted. Here in our definition, Madam Chair, precisely, we have included all of them
Yes.
so that they will be all classified. But that is your process now. But certainly, all of these 4 are supposed to be only in the hands of the responsible people in the Armed Forces of the Philippines, correct?
Yes, sir.
And all of these are the officers of the AFP are not allowed to share all of these 4 classification to any private person until authorized, or by the government until authorized.
Yes, sir. In the different classification, there are different authority.
To give to clearance. Okay.
Yes.
I will ask the Philippine Coast Guard, who is fighting it out, and I'd like to state that we support Jeta Riela against this Chinese, because Jeta Riela is fighting for our country, and we support him fully. Let us not be bogged down with this new Chinese ambassador who are distorting the facts with their cronies, Philippine traitors, who are giving out information coming from the embassy. So we support Jeta Riela. So can we have your classification?
Thank you for the statement, Your Honor. In behalf of Commodore Tariela, thank you, sir. Thank you. Again, Your Honor, the same with the Armed Forces of the Philippines. The Philippine Coast Guard has the same classifications when it comes to the document, from top secret, secret, confidential, and restricted. And it also follows, Your Honor, as to specific persons or offices that are authorized or allowed to open such documents, sir.
But you are a civil agency. The Armed Forces is the defense department, and so you are following civilian authority is following the AFP definitions.
To correct you, Your Honor, the Coast Guard is a civilian in nature, but we are a uniformed service. That's why we copied what the Armed Forces has, Your Honor.
So you copied, but it is clear that you are civilian in character.
Yes,
because
Your
you're
Honor.
under the Department of
Transportation, Your
Transportation. So therefore, but you therefore had made your own. You cannot follow them. You have your own circular, which follows that, but it will be your own. Do you have that?
Honor. Yes, Your Honor, we have that, Your Honor.
Okay.
And do it the same, with that, the same classification,
Okay.
Your Honor.
Thank you. Madam,
Madam
yes,
Chair.
somebody's raising his hand, but before him, I'd like to ask Nika. Oh yeah, Nika, you're Nika, right?
Yes, Your Honor. Madam Chair, Your Honor.
We will yield to Director Badle.
Higher in rank.
Director Badle.
So we ask the director.
Thank you po, Madam Chair, Your Honors. Actually po, access to classified matters is covered by an executive order, EO 608 po, sir. So, all the government agencies has a, they have a uniform classification of documents po. Nabanggit naman po, top secret, secret, confidential, and restricted. And every personnel po of each agency has his own access po. Not everybody can access. Meron po siyang clearance. The agency involved po can issue temporary po interim clearance, and the National Security Advisor is the one issuing the final security clearance po. Subject for security check po. So, lahat po ng personnel natin, hindi po yan pataasan ng rango, but depende po doon sa access mo. So, not everybody can access to top secret, not everybody can access to need to know po, tsaka limited po siya. Nasa discretion po ng head ng agency if kung sino lang po yung personnel to be given clearances for classified matters. Tama po yun, classified matters refers to yung apat na classification po. Apo.
Just to clarify, so there's one unified definition for all government agencies, and you have these 4 subclassifications. Top secret, secret.
Yes, Madam Chair. In fact, hindi lang po tayo, but internationally po, yan po yung accepted po na protocol sa classified matters.
Madam Chair,
Yes.
may I just clarify a point? I understand that that's Executive Order number 608 that was issued in 2007, but that applies to who may access classified matters. Is that correct?
Yes, Your Honor.
And when we talk about yung apat po na categories, that would come from Memorandum Circular number 78, which was issued way back in 1964. Tama po ba yun?
Yes, Your Honor. In fact, the NICA, the National Security Council po, ito po yung ginagawa natin ngayon kasi masyado na pong matagal yon. However, the DICT is now, dahil nga po yung EO 64 and 68 po, wala pong AI doon, wala po yung cyber. Now, ina-update po namin yan in coordination with the NICA and other agencies kasi po, sabi nga po natin, the DICT is now drafting EO, wala pa pong pangalan, but ang focus po nila is doon sa AI and doon sa cyber. So, ito po yung wala sa 64 and 68 version po nung 1964 pa po. Tama yon. So, ito po yung pina-fast track namin in coordination with the DICT. So, meron na po kaming technical draft, naka-draft na po siya, but kailangan po kasi yan interagency. Tsaka ang coverage po kasi dahil EO, hindi po covered yung ating Congress tsaka po yung Justice. Yun po yung pinag-uusapan namin yan, Madam Chair, Your Honors.
If I may, just one more point, Madam Chair. One of the concerns I have is that the definition of classified matter as proposed does not include the phrase that is found in the original law relative to the defense of the Philippines. Perhaps my concerns could be assuaged if we can add that, because if we, without that phrase, we are giving to the administrator of the government complete leeway in terms of what they can deem to be sensitive. Since espionage refers to the defense of the Philippines, perhaps we could add that, and that way, my concern, I would be more open to this kind of definition. Thank you, Madam Chair.
For me, thank you, Kong Diokno, that actually makes sense. Kong Tony Boy.
Question. Not quite familiar with the executive order or the memorandum circular mentioned by Kong Diokno. Does it provide for penalty for misclassification of documents by a record custodian or whoever's in charge of classifying the documents as classified, trade secret, top secret, confidential. Is there a repercussion for misclassification of documents?
Meron po. But it's more of sa admin po siya, hindi po siya, wala po siyang, yun po yung kulang natin, wala po siyang penalties, wala po. Yun po yung idadagdag natin sa revision po. That is ongoing po, Madam Chair, Your Honor.
In that regard, maybe a reference to administrative penalty for misclassification of data or documents would help. For misclassification, it's here. Okay.
Let me just answer Congressman Tony Roman. These acts clearly has penalties. And here, we have here imprisonment, and then without benefit of parole, and benefits of good conduct time. So it's here. Now, administrative, this will be more of a criminal statute. That's why administrative will be dealt with the agencies. So it's here.
Yes.
Section 5, last paragraph. This is all the illegal prohibited acts under Section 5. The 6 paragraphs after that, Section 5, we have the penalty. Very clear, very stiff. Let me just answer our Congressman Chel Diokno, my good friend. With due respect to Congressman Diokno, if we will just have confidential, we're removing the 3 other classifications, especially top secret and secret. Now, you know, our journalists are always protected if they get the source from the proper authority. But no journalist should be able to publish, talk about all of these classified matters without the proper authority. So they're protected because if they publish classified matter and then they have the permission to do so, probably it was brought out in a public announcement and discourse, and that is open out to the public. But if it's not, so there is, I don't see any was this chance that a journalist with a proper authorization and who has heard it through pronouncements like from J. Tariela will be liable. So that is why we would like to stick, Madam Chair, to possessions of a classified matter, because classified matter is already defined clearly what it is, including the 4 kinds of classified materials. And also, it is clear that we cannot also agree that it will only be classified material for national defense because critical infrastructure is defined. And meaning, all of this in critical infrastructure, of course, would lead to the fourth line of the paragraph, debilitating impact. See, it has to be debilitating and an impact on national defense and security, national economy, public health or safety, the administration of justice, and other functions analogous thereto. So therefore, there is a statement here about critical infrastructure. And all of these people, a government or administrator of these critical infrastructures, which may deem certain, like for example, at the time when there was this virus in Africa, during the President Aquino, President Noynoy Aquino, I was trying to state about the problem. The President called me, Rufus, please do not talk about it because it will unduly make our people scared of all of this. So just keep silent and I follow my President. So I kept quiet. These are times when public health and safety are involved. There is the President himself who is asking me not to talk about, not the Ebola, there was another one, which was already coming to the Philippines. So I did not talk about it. So therefore, all our agencies will have, the heads of these agencies will know their critical infrastructure, and this is the four classified matters to Congressman Diokno. But he has a very good point also about protection of journalism. Thank you.
Thank you, Chair Rufus. Congressman Roman.
Thank you, Madam Chair. The penalty provided in Section 5 refers to aforementioned acts or violations, none of which cover actually misclassification of data. My concern is related to concern of Kong Jokno, because in the definition of classified matters, it says it depends on the discretion of the authority. So if it's so classified, if the person deems it classified, then it is classified. So that's why I raised I suggested that maybe, I just want to rule out the possibility of deliberate misclassification to actually conceal or withhold data. Because, to address the potential arbitrariness of a decision to consider data classified. I'm not sure it's worth inserting here. Mr. Batle mentioned that the executive order provides for administrative penalties for misclassification of data, no? Because potentially, there are interests at play that are not apparent. So if I'm the record custodian and I have information that is by nature non-confidential, in other words, should be accessible to the public, but for whatever reason, I consider it classified, then they have no access to that data or information. Or because I just said so. So my concern is, yes, we have the parameters given in the executive order and the memorandum circular, but what if the person does not really abide by that, right? So, in other words, misclassifies the information. Is there any penalty provided for that person? Yes, it's mentioned it was administrative nature. So, just a thought for the committee, maybe a sentence or two to the effect that, how is it worded here? In the definition of terms, misclassification of information or materials, it shall be dealt with administratively or something. Words to that effect would help.
Madam Chair.
Thank you. Chair Rufus, can I just recognize Representatives Roger Gaviolo Mercado of the 1st District of Southern Leyte and Representative Laila M. De Lima of the ML Party List. Good morning po. Going back, we heard the suggestion of Representative Roman that the misclassification of data, of classified documents.
Also, misclassification of otherwise non-classified matter, or misclassification of otherwise non-confidential matter.
Be included. Can we solicit the comments of our resource persons? Let's start with the PNP.
Good morning,
and
sir.
then I'll go to ma'am.
The PNP, ma'am, also follows the same and similar classification and access to classified information, classified matter. When we say classified matter, this encapsulates all from top secret, secret, confidential, and restricted. These are not readily available or for public consumption. So even the restricted ones, even office order is considered as restricted. Now, the responsibility of classifying a particular document or information emanates from the originator, kung sino po yung nag-provide ng information. Depending upon the consequential damage it can bring about to the state. Now, if a particular information, whether it is a particular name lang, would bring about a inconsequential damage to the political, economic, and the state, he may classify it as a top secret. Now, pag may classified na siya, sir, as top secret, may levels of clearance na po. Color-coded na po yun. Usually, it has a cover sheet. The green ones are intended for top secret. The red ones are for secret. The blue ones are for confidential, and the black ones are for restricted. So may respective cover sheet po siya. Now, for those unclassified, I don't know for some other agency, but for us, yun po tinatawag namin na unclassified, but for official use only. For official, it may not be distributed to the public. It's unclassified.
Madam Chair, Colonel, the question of Congressman Roman, and you answered this, are you in favor of putting this bill penalty for misapplication of classified information? That is a question. So what is your stand on that? To put on the bill that to therefore make sure that agencies will not be abusing the authority to classify, that we put here in the bill a penalty. So what is your answer there?
Chair, to add to that, maybe the question is misclassification of such data, does that amount to espionage, which we are...
No, it's not. It doesn't relate to espionage. It's really meant to check potential abuse or even error. Because, again, if motivated, if driven, or if motivated because of ill motivation, like wrong motives, bad motives, an officer deliberately misclassifies it to shield it from the public, for example, to shield it from access, di ba? Like something that is it doesn't really relate to national or doesn't affect national security, but for whatever reason, he classifies it as classified matter. Yun pa. So my question and suggestion is including a provision here that that penalizes knowing misclassification or deliberate misclassification of data. So, but that's not in espionage. It doesn't relate to espionage. It's just as a reminder to whoever's in charge in the agencies to do their jobs honestly. You know ang aking suggestion.
Okay. Thank you, Kong. Can we just get the comments of the lady over there?
To second my boss, Director Butler from the National Security Council, we are guided by the Memorandum Circular Number 78, Series of 1964. This Memorandum Circular defines what are those top secret matters, confidential matters, and restricted matters. So if we are going to be technical on including only confidential in nature, allow me to read the definition of confidential matter under MC 78. No? Information and material, the unauthorized disclosure of which, while not endangering the national security, would be prejudicial to the interest or prestige of the nation or any government activity. So if we are going to limit the term of the classified matter to confidential, it might not include matters which will endanger national security. So we are of the position that all classifications in general be termed as classified matters be included in the term of espionage. With regard to the concern of misclassification, we are of the position that misclassification, with all due respect, is no longer germane to the espionage, to the bill. We are, although we understand the concern of having safeguards with regard to classifying matters, but we believe that this might be a subject of another, might be a law or another executive order, or maybe a reference of that law or matter into this pending bill. With all due respect po.
Thank you, ma'am.
Let me just respond to that. I think it's absolutely germane. Because you're talking about classified matter, which presupposes classification. And the person classifying is a human being. Therefore, you have to, not all of us are have the proper motivation. We could have we have a respective agenda. So, and it lends itself to abuse. So I've seen in many laws, what they do is that if it's within the ballpark, they include it.
We do understand po the concern po, but not all classified matters usually not all classified can relatable po to espionage.
That's not my question. I'm talking about misclassifying. You have something that is from every angle non-confidential. Now, for reason known only to me, as a person classifying it, I deem it, it says deemed, I deem it classified. Now, it's beyond the reach of the public. So what's the consequence for me?
Madam Chair.
Yes, Chair.
Yeah, Taniera, you had a very good exposition in the first part, which are totally wrong in the second one. I want the nerve to question the congressman on this being germane. You should not do that in this Congress, because this is germane. We're talking about possible misapplication, and our congressman is concerned. So therefore, let me answer the question of Congressman Tony Roman. There is no need, Madam Chair, to put in this law penalty for misapplication. First, there are two principles in administrative law. The first principle is the principle of regularity of public functions. We give that presumption to the agencies in this critical infrastructure. So there's presumption. If there's a question, then they go to court, they go to the higher authority in the administrative field. The second one is the principle in administrative law of primary jurisdiction. They have the primary jurisdiction about national security, AFP, NICA, public health, DOH. So therefore, it is not necessary, because if we put a penalty here for misapplication, which will counter these two principles of administrative law, then we will be discouraging our agencies from coming out with their classification and being afraid that there might be misapplication, and then some people will be filing case against them. So let them do that and let the court decide, because these two presumptions in administrative law still holds under our administrative code of 1991. So therefore, with due respect to my good friend, it is not necessary here. Let us have this bill to warn everybody, Filipino and foreigner, that they cannot be divulging matters which are classified with 4 categories. Thank you, Madam Chair.
Thank you.
Madam Chair?
Yes, Co-Chair. Go ahead,
maybe
please.
just 2 points for us to give clarity and maybe resolve this matter. First, I think we have to discuss how the document is being written. For sure, there is an analysis and a vetting process before it's being classified. That way, the lawmakers will understand how do you do your job, especially for classifying these documents. And I'm sure there's a confidential paper trail for this. And secondly, I think another problem is because of the old school notion of looking at criminal law that it has to be elements-based all the time. That's why there's an apprehension that there might be abuse in terms of classifying documents as classified matter or confidential. May I know from the resource person if what are your thoughts on this? Specifically, what if we shift our view when it comes to espionage, a non-traditional crime, into looking at the holistic effect of the actions of the possible perpetrators? So just those 2 points, may we hear from the resource persons. Thank you.
Thank you.
Attorney Arcelias.
Thank you, Madam Chair. So I think the way that classifications are made has been comprehensively discussed in MC 78, which is available in public. And to I understand where you're coming from, but I think the MC78, the good thing about the MC78 is that it provides safeguards so that the original classifying authority or the recipient of the classified matter can be downgraded if the higher authority deems it to be of lesser classification. Thank you.
So just to address the point raised, Madam Chair.
Okay, go ahead.
Sorry, I don't want to drag this conversation, but ultimately it's going to be classified or not. So the fact that the decision making is tiered really does not matter. And at the end of the day, from the point of view of the public, it's either classified or not, right? And we cannot discount the possibility that if the superior says there's an influence, he has influence over his subordinates also. So that's I'm just putting it out there because we cannot discount that. Now the concern is this: I understand the points, and it's well appreciated of Kong Rufus about presumption of regularity, a doctrine of primary jurisdiction, but these only relate to burden of proof. It is not really a defense. What I'm proposing is not really to include specific administrative penalties here, but include language to the effect that deliberate misclassification of data, we'll refine it, will subject the violator to administrative sanctions. Something that is just a reminder. We're not saying exactly what penalties, but that language that violator, deliberate misclassification of data will subject the violator to administrative penalty. Yun na po ang akin,
Okay. Any more? DND? Yes, Attorney Calderon, please.
Good morning, everyone.
Good morning.
So we've heard a lot about MC78. So MC78 is a guideline for the departments to classify information. So as a classified matter, it provides the guidelines for the departments, for example, to say which information is top secret, which is secret, confidential, and restricted. Much like what the from the PNP has said, there are rules that you put on a cover page to indicate clearly the classification. It's also color coded. And as to the question whether it's important to put administrative or criminal liability for misclassification, I support the position of Honorable Rufus Rodriguez that it might not be necessary because to maybe in very broad and simplified matter, this is how I understand the process. For example, I'm foot soldier, and I come across a information, and I'm going to make a report. Upon making that report, I'm already allowed to put a classification, so that only the right people with the right clearances would be able to see this report. So if there's an extra burden on me because of misclassification, much like what Honorable Rufus Rodriguez said, it might hinder me from putting from my assessment, the correct classification. And much like from our colleague said, the person who will receive this report would eventually see, all right, it's upon my assessment that from top secret, this is actually just confidential. they're able to downgrade or even upgrade the information. Because sometimes the people doing the report are not aware of the other information the top leaders would have. So that's my take, Your Honor.
Thank you, Attorney Calderon.
Madam Chair, we have sufficiently discussed, unless some members would like to. Yeah, I yield to, of course, former Secretary of the Department of Justice.
Thank you.
Congresswoman Laila de Lima.
Go ahead, ma'am.
I see the point and the wisdom in the proposal of Congressman Roman. I don't see anything fundamentally wrong or questionable if we place that provision. But I think to address the matter about the presumption of regularity of performance of official functions, maybe we can add the descriptive word deliberate misclassification. I don't see anything questionable or fundamentally wrong as a deterrent to any willful, deliberate act of misclassifying data or facts that can have serious consequences. That's my point. That's my view. So therefore I support the proposal of Congressman Roman.
Madam Chair, we are trying to have a bill that will discourage and bring to justice spies. And if we have some kind of a statement which will put a monkey wrench on our administrative officials, they will be afraid to just perform the duty. After all, they can go to court. When we approve this, somebody feels that, misclassified, then they can have administrative or they can question this in the judicial forum. But if we put it here, we are trying to have a strong anti-espionage law. So that's why I would again beg to disagree with the Honorable Laila de Lima. To me, it's not necessary. So with that, Madam Chair, I call for a vote. I move for the approval of Section 5 to move forward.
There's a motion to approve Section 5 as worded, and of course, subject to style.
Subject to style.
Yes, subject to style.
To incorporate the suggestions of the Committee on Defense.
Yes.
I'm not a member of the Committee on the Revision of Laws, but I am a member of the Committee on Defense. So
Yes.
we have our own suggestions.
Yes,
And
as
the
earlier,
Secretariat will forward that to your Secretariat.
Madam,
Yes, Com
Madam
Arna.
Chair. Yes, may I just register my objection, especially in particular with Section 5 in relation to Section 3A, and propose as well an amendment to the definition of Section 3A on classified matter to include at the end of the first sentence the phrase relative to the defense of the Philippines, so that it would be clear that the officials concerned who are doing the classification can only classify it as a classified matter if it is relative to the defense of the Philippines, since we are, after all, talking about espionage. Thank you, Madam Chair.
Thank you, Kong Diokno. We will note your objections. We will record them. And there, again, as earlier stated, there is a motion to approve Section 5 subject to style. That will be forwarded by Congressman Arnon Panaligan to our COMSEC. Do we have?
Madam Chair, sorry. Last point. I just want to respond to the reservation of Representative Jokno, because as we have observed in the last couple of years, the arrest of suspected spies no longer limit their collection of information on defense. They're already going after information on national security, including the COMELEC, including police force. So I think for us to be comprehensive, we have to include other information relating to national security. Another, Madam Chair, just tweaking in the in Section 5, because right now the wordings of Section 5 is that which tends to give advantage to nation or security in order to limit the advantage to other foreign nation, maybe we can include the word other foreign nation so that those activities conducted by the AFP or the intelligence agency for the benefit of the Philippine nation or the Philippine state will no longer be included in the espionage. Thank you, Madam Chair.
Thank you, Attorney Arcelias. Again, is there a second? Okay, the motion has been seconded. We approve Section 5 of the draft bill. Now we proceed to Section 6, conspiracy to commit espionage. Do we have any comments on this provision?
Move to approve because conspiracy is always another kind of commission of a crime. And so if there is conspiracy, meaning those who did not actually do it, but are the ones who planned to get this information. So I move to approve Section 6.
There's a
Madam
motion
Chair.
to approve Section 6. Do I hear a second?
Seconded.
The motion has been seconded. We approve Section 6 of the draft bill. We proceed to Section 7, proposal to commit espionage. Do I have any comments on this provision?
There is none, Madam Chair, so I move for approval of the proposal to commit espionage.
There's a motion to approve Section 7. Do I hear a second? Okay, the motion has been seconded. We now approve Section 7 of the proposed bill. Now move to Section 8, acts of destruction, interference, and obstruction. Do we have any comments? Or do we have any recommendations regarding Section 8?
Madam Chair,
Go ahead,
may I
Co-Chair.
ask for comments from the DOJ and the AFP on this? Specifically, this is just a hypothetical scenario because some of the things that are being collected from the Philippines is maybe not physical documents. Like for instance, a foreign nation invests on a community of highly respected individuals in your country. They get information from persons of authority, and then they collect all of these data together to form some sort of a report to their foreign country. I want to understand if is this scenario covered, or do they have any suggestion in terms of the language in order to include this in the proposal?
Interference yung hiwalay na.
Baka lang po.
Sige.
Pero kung gusto nilang i-delete it, so
May we ask for comments? Or maybe Nika wants to give their input? Specifically, I'm pertaining to certain information that's not necessarily documents, and it might be through other means like communication and then just patched together after by certain groups of individuals.
I'm sorry, I did not get your question. Sorry.
Okay. Since I think earlier the discussion was isolated when it comes to documents being classified, and then these the informations of that documents are being provided to someone who is not authorized. But what if the scenario is this? Not the whole document is presented. Only the information is passed through another person, and that information is being narrated and collated for purposes of espionage. How do we answer, or is this already answered in this bill?
Kong, I think the word dealing in Section 5 has already covered this act, like transmittal or interference in the transmittal of classified information. So not just access or obtaining.
So purposes of the deliberations of this bill, does it include passing of information orally also?
Yes.
All right. Thank you.
Thank you.
Thank you. Thank you, Attorney Arcelias. One question regarding Section 8. Is it proper to include interference here? Especially since in the last meeting we talked about having a separate bill for foreign interference. Yes, Attorney Calderon, go ahead, please.
Good afternoon. Good morning, Your Honor. In this case, I think interference is acceptable in this case because interference here looks closely more like sabotage, which is already included in CA 161, wherein it's actually interference for the purpose of sabotaging defense operations. Might I just add some comments? So one of our goals is to not put differentiation between war and peacetime. Maybe the phrase against armed conflict might put to the direction of a wartime aspect. And then in subparagraph A, there's the phrase defense or national security material. I note that there's a definition for national defense material, but the national security material appears to be undefined. Thank you, Your Honor.
Thank you, Attorney Calderon. We note your comments, and we will go back to the definition of national security material later on. Any further comments on Section 8?
Madam Chair,
Yes, Kong Panaligan.
regarding Section 8, Paragraph A, or Section 8, letter A, can I suggest to put the word deliberately making or causing to be made any national defense or national security material in a defective manner? Can we qualify that with the word deliberate? Because my concern is that we recently passed the Self-Reliant Defense Posture Act. And the purpose of that act is to encourage the development of domestic or local defense industries. So maybe we are not yet perfect, no? And we are still on the trial stage. And maybe if we manufacture an armament and that turns out to be defective, kawawa naman yung ating mga domestic industries na baka sila ay makasuhan na because of this. Ano? So can we put their deliberate? Can we qualify that? To protect our local domestic defense industries. Maybe we can ask the comments of the of our people from the DND and AFP.
Yes. From the AFP, sir? Would you have comments on
Because
Section
my
8
comment,
as-
Madam Chair, is it might affect our domestic defense industries that SRDP encourages.
First, sir, yung question kanina pertaining to interference, I think the interference as defined here is not referring to foreign interference. It refers to interference on the national defense efforts or operations. And pertaining to materials, sir, we also had proposal on this low class quality or materials, but in different section. We will only submit our proposals, sir, upon the guidance of the DND.
Okay. Attorney Calderon.
Good morning, Your Honor. As to the insertion of the word deliberate, we submit to the discussion of this honorable body, considering that there's the word deliberate would go into intent, which again goes back to the discussion of mala in se versus mala prohibita. So we will submit, Your Honor.
For the AFP, sir, can you provide the committee with your draft in Word version so we can include in the substitute bill your comments on this?
Yes, ma'am, this afternoon, ma'am.
Thank you. Yes, Attorney Aspiras.
Thank you, Honorable Chair. For the Department of Justice, we interpose no objection with the inclusion of the term interference here. Because it's already mentioned, it pertains to national defense, while foreign interference, the foreign interference bill pertains to the purpose of which is to malign purpose of manipulating, disrupting, infiltrating, obstructing internal or external policies in the affairs of the Philippines. And with the inclusion of the term deliberate, we defer to the wisdom of the legislature on that. Thank you, Madam Chair.
Thank you, Attorney Aspiras. Yes, Colonel Abesa.
Ma'am, with the term deliberate, sir, from a law enforcement standpoint, it would be very hard for us. It would be hard for us to establish and provide proof in order to successfully prosecute a case under Section 8. So, considering that this one is the survival of the state is at stake, the national security is at stake. So we raise our apprehension on the inclusion of the word deliberator. Thanks, sir.
Any further comments? No more. So let us. Yes.
This being mala prohibita, then the scienter of the crime will include intent, because precisely mala prohibita will be, you will be proving that, while in mala ense, no need, because that is in se. So we don't need anymore the word deliberate. It will be part of the proceedings. And again, as stated, if we will put deliberate there, it may be misconstrued by judges and others that it will be difficult to be able to prosecute them. So I would rather that we stay with this Section 8, Madam Chair, and so therefore I move for its approval.
Okay. We have a motion to approve Section 8 as originally worded, subject to style. Okay, the motion has been seconded. We now approve Section 8 of the draft bill. Section 9, disloyal acts or words affecting national security, national defense, and critical infrastructure. Can I have your comments on this section, please? Go ahead.
Yes, ma'am. Let me know, ma'am, who are the government employee whose function is critical to the preservation and promotion of national defense and national security. Is it defined under the section?
Actually, it hasn't been defined. This provision comes from earlier draft bills, and
National defense is quite clear to everyone, including laymen. And also national security, there's no need to define this, Madam Chair. So those in the national defense, whether it will endanger our defense and our security, then they are government officials. It's very clear here, not journalists. This is a very clear imposition of government officials who will be the one that will be coming out inciting others to be in favor of China. Yun. That's the best example. So government yun. Journalists are not included here unless they are journalists who are connected with the agencies. See, because there are some agencies retaining some journalists. Yeah. So, but this is really for government employees that are in the national defense. Also very limited. National defense lang and national security. Although there's critical infrastructure, but clearly, I think we should remove critical infrastructure because Section 9 is very clear to the protection of the protection of critical infrastructure, including public health, safety, and so forth. So, but still, this pertains to government officials, the Secretary of Health, yan, Secretary of National Defense, and other government officials in the defense and in the security and also critical infrastructure, Mr. Chair. So this is very clear, very limited. Ito. Thank you, Mr. Chair.
Thank you, Chair Rufus. Actually, for Chair Rufus, I just tweaked the wording of Section 9 the past few days. As you originally drafted, I just fixed it a bit.
This one, Mr. Chair. So I move for approval of Section 9.
Go ahead, Colonel Abesa.
Just observation lang po, sir. With respect sa Section 9, observation from the PNP is this is a criminalization on the part of a government agency, a government employee. Now, this is in times of war or in times of peace, regardless, sir. Now, how about if a civilian or a private entity during times of war, do we not exact loyalty from them? Or is it not a criminal act to be disloyal to the country, even during times of war, even by simply committing any of these?
They will fall under Section 5. If they will be using classified information, but this one is directed towards government employees. So that's why it is here. Now, this will not include criticisms to the President, because these are some political acts of policemen and the armed forces. They have the right to criticize anybody in this country. So therefore, these are merely for national defense, especially and critical infrastructure. So these are for government officials who will be violating this. Yeah.
And I think the acts mentioned by Colonel Abesa are already punished in the RPC.
Does this act qualifies inciting to rebellion or sedition if a person encouraged the armed forces to withdraw support from the president?
Chair Rufus?
If military personnel will criticize the president and ask to overthrow the government, that will be inciting to sedition. But what we're saying here is that this is only for those who are going to have disloyal acts of words in relation to national security. Okay, so that is what we have here.
Good morning, Your Honor. Can I make a suggestion or observation that paragraph D, obstruct the recruitment or enlistment efforts of the military or the uniformed personnel during armed conflict, be instead included in Section 8, because it's more similar to another form of sabotage.
To include Section D under Section 8.
Yes, Your Honor.
Subsection D of Section 9 under Section 8.
Once again, Madam Chair, this is really for government personnel, government officials. So that's why if a government official will be the one, a colonel in the armed forces would obstruct the recruitment and enlisted efforts of the military, then he will be liable. So this will be fine under government employees. Otherwise, if we put it in 8, it will be in general. So move, Madam Chair, Section 9.
There's a motion to approve Section 9. Do I hear a second? The motion has been seconded.
Yes. Clarification, Madam Chair.
Yes.
So, this section, letter D, will apply only during armed conflict.
Chair Rufus.
This is very clearly under this, Madam Chair.
Yes, under
this is it does not refer to armed conflict. Only because only Section D,
Section D
is to armed conflict lang when there is an armed conflict.
So,
because if somebody would say about not to enlist at this time, there's no armed conflict, there's no problem. So this armed conflict is only mentioned in paragraph D.
I see.
Not in the others.
So would Congressman Rufus be amenable if we just delete this phrase during armed conflict? So even if there's no armed conflict, even at peacetime, if there is if somebody obstructs the recruitment or enlistment of the military, that can also be punished. I leave that to the discussion, of course, of the members.
The chairman especially.
We leave it to the proponents, the main proponent.
That would be more strict, of course,
Do we want a stricter?
and more encompassing.
Because the obstruction of recruitment or enlistment during times of peace, there may be some reason why they would not over na ang kwan, ang PNP, over na ang BGMP.
Okay na lang.
May problema pa sa Bureau of Fire. They are on fire. So I think we should put still during armed conflict so that medyo may leeway naman din ang mga officials to voice out in times that we are still on peace. Yes. Thank you, Madam Chair.
Okay, thank you very much. The motion to approve Section 9 has been seconded, so we approve Section 9 as worded. Section 10, unlawful possession or control of surveillance or mapping equipment. Do we have any comments on this section? Yes, Attorney Arcelias.
Thank you, Madam Chair. Madam Chair, just to classify the kind of equipment or device that we control, maybe we can include a provision that designate a specific office, either from the DICT or any other office, which will release every now and then the kind of specifications of the surveillance equipment that shall be prohibited from sale or possession. Otherwise, if you look at the wordings of the law, mere possession of a cell phone may already be part or covered.
Attorney Arcelias, can you come up with a proposed wording for that?
Will do, Madam Chair.
Any comments? Any comments on the...
Chair, very important missing in the enumeration, drones. Yung drones na ang ginagamit niya. May camera ngayon, pero yung drones sa specific meaning, yung mga drones na ginagamit, ipafly pala yan sa Camp Aguinaldo, yun. Then our Villamor Air Base. So, just to include here, that limited to drones, cameras, listening or tracking devices, or any other technological means for the purpose of surveilling, monitor. So, just the inclusion of the word drones.
Okay. Any more comments? Softwares. Go
Software
ahead,
for the purpose of...
Where will we put software?
Drones, cameras, listening, softwares, listening
I think,
or
sir, that's
tracking.
part of the collection effort of, we will put software or AI-enabled software for the collection of information.
Thank you.
Where would our gentleman put this in the lines?
After cameras.
Which lines?
Before listening or tracking devices, because they are.
Probably, ma'am, a generic term that any other means.
It's already here, other technical means.
Any surveillance system or equipment or software.
Okay.
Okay.
Software, yeah.
Any surveillance system or equipment or software. Thank you, sir. Any
Chair,
further?
Can we
Yes.
suggestion only? Can we just remove the word technological and just say or any other means, so it's broader and more encompassing?
Thank you, Kong Arnan.
Just a suggestion.
Yes, that suggestion is well taken.
And also regarding the making of a map or any representation. Not just the map that we know,
Yes.
map or any representation.
Any further comments? Ladies and gentlemen, we have good suggestions on this. Okay?
Thank you. Thank you, Congressman
We
Rugos.
accept the suggestions of Congressman Arnan Panaligan. Now, can I solicit a motion to approve Section 10 as amended?
Move to approve.
We have a motion and it has been seconded. So we approve Section 10 subject to style, subject to the wording
Mali ang number.
of Attorney Arcilas as well.
Section 11.
Section 11, aiding or abetting. Any comments? Or any motion to approve Section 11?
Sa'yo.
We have to put here a higher penalty if it's a government official who would aid or abet anybody to commit this. So a higher penalty for government officials. They're in government, so their loyalty is only to the republic. And so therefore another sentence here, any government official or employee who abets, so of course you have the penalty of 12 to 14 years of imprisonment and a fine of less than 15 million and 25 million. So that we will bankrupt this public official. So move, Madam Chair, with my
There is a motion to
my
approve
motion.
Section 11 with the amendments of the proponent.
So when
We
it
have a
is a
second.
government official, you have a higher penalty. Because here, any person So that pertains to non-government officials. But government officials na, diyan talaga, it will be higher. Thank you. So move, Madam Chair.
Thank you. Do we have a second? We are approving Section 11, ma'am, as amended by...
Just a clarification, Madam Chair. So it should be another paragraph.
Yes.
So far as government official are concerned.
Yes.
I second the motion.
Thank you. Thank you, Congresswoman De Lima. Philippine Coast Guard. Let me just first say that we have approved Section 11. Okay, the PCG has no more. Okay na po? Okay. Section 12, harboring, concealing, or facilitating the escape of violators of the law. Do you have any comments, suggestions, or motion to approve this section?
We move for another paragraph to be able to deal with government officials and employees abetting or harboring, concealing, or in facilitating escape of violators. This will be for the Bureau of Corrections. So that, so it will be again be 12 to 14, 15 million and 25 million, Madam Chair. So move, Madam Chair.
We have we have a motion which has been seconded. So we approve Section 12 of the draft as amended. Section 13. Actually, we have here the liability of government officials and employees, military officers, and personnel, foreigners, and juridical entities. In the last meeting, there were suggestions from I believe the AFP and the PNP to include juridical entities. So we have included a provision which we have a provision on juridical persons, juridical entities. Excuse me. May I solicit your suggestions or comments on the draft, since we touched on this portion a little lengthily last time.
Madam Chair, in the third paragraph on the juridical person, I think we should remove already any equivalent rank of officer. This is quite vague. And we have already mentioned those who are responsible, so not to prevent the prosecution of others. No? So if it's a juridical person, it's normally the president, the partner, the director, the trustee, the chairman. Can we include here chairman? The partner, comma, chairman, comma, president, and so forth. But then we will remove already the any other equivalent rank. So who are the other equivalent rank? So it's an ambiguity. So therefore, it will end with an treasurer or finance officer. That is sufficient already to be able to bring into justice a juridical person's representatives. So move, Madam Chair.
So we will amend the section by removing those portions stated by Chair Rufus. For the benefit of those who weren't here last time, can we get from maybe the PNP or the AFP or the Coast Guard an example of when a juridical person will be held liable, or a clear example of when they will be held liable under any of the crimes? Go ahead, sir.
Good morning, Your Honor. This is a separate concern, Your Honor. Considering that we've added a separate paragraph for Section 11 and 12, then we have Section 13 when it comes to government officials. It is as if I'm not mistaken, Your Honors, we will be that for example, a government official will be prosecuted for a single offense, but with two different possible punishment. The one that we included in Section 11 and 12 and the first paragraph under Section 13, sir.
Madam Chair, it's not that situation. It is just an additional. It is perpetual disqualification. So they will suffer the higher penalty in accordance to 10 and 11 and 12. But then the additional penalty here for government is absolute perpetual disqualification from holding any appointive or elective office.
We can, if this will address your concern, sir, maybe we can remove the phrase, the maximum penalty provided in this act, considering that we're already laying down the penalties under Section 11, Section 12.
I agree with the chairperson.
Any more comments, sir?
What is the example of a juridical entity being used for espionage in this country? Can you answer that? Because I know a company. Just been out already in the open. May we know what company is that?
We will find out, sir.
Oh, you're not. Jeta Riela has been saying this. There is a company here in the Philippines where all the other journalists or in the payroll get their public releases, their PRs, and also money. What is that? Because you should know. Because that is coming from Jeta Riela. Mayroon dito in coordination with the Chinese Embassy, mayroon sila ditong company. Doon sina-channel yung pera. Ano yung pera? Binibigay sa mga pro-China journalists of the Philippines. Don't tell me you don't know that.
I cannot.
You are the one in charge of protecting our West Philippine Sea,
Yes,
specifically the Coast Guard. So who is that?
The representative here, Your Honor, has no authority to discuss.
No, we can ask you because it is a public knowledge. This is not classified material. It is not secret, top secret, confidential, nor restricted. It has been announced that there is here a company, a PR company, being used by the Chinese Embassy to be able to echo the disinformation and fake news of the Chinese government?
Chair, kayo na po ang magsabi.
It's case me the name now but I have read it. So I think the person should know, should be Coast Guard. There is a company here. Lumalabas na yan eh. O ano yun? Can you, so that it will be on record? So that they can dissolve their company. Otherwise, their president, ano yun? Ano yun?
We'll find out for now, sir. We'll provide that
For the end of
before
the hearing, okay.
Thank you,
Kasi
sir.
we want to really show na the Chinese is also manipulating our own journalists and bloggers. Okay. Thank you, Madam Chair.
Yes, Colonel Abesa.
Ma'am, in response to your query, with respect to juridical entities, perhaps juridical entities can be liable if the companies, juridical entities, was set up primarily for or as a disguise for obtaining classified information, or they blindly, by negligence, they allowed their company to be used for for surveillance and espionage purposes.
Colonel, no company will put in the SEC registration that they are going to be spies or to promote the interests of China.
Yes, sir.
So
Yes, sir.
that's not, there are those already organized. These are already existing companies, already registered in the SEC. And now they have also done these things of, mouthing the Chinese line, you see. So, hindi lang, so I think this will stay. Madam Chair, it's clear, all juridical persons, whether they are incorporated to state that purpose to spy on the Philippines. Will that be in the application of the SEC? It will not. You see? So therefore, we cannot have that. Okay, thank you, Madam Chair.
Okay,
Move to
thank
approve this one.
Okay, we have...
Madam Chair?
Yes.
Just a comment, because Section 13 applies to government officials and employees, among others, so that includes personnel of the AFP, of the military, correct? Now, in one of the hearings last year, Secretary Teodoro suggested that military personnel, active military personnel, be tried by, of course, General Court Martial. And even if they are discharged, he prefers that they still be tried by a court martial so that they can have control over the erring personnel. So I don't know if it is proper to include here as a provision that military officers and personnel charged with violations of this Espionage Act, while on active duty, be tried by a general court martial under the Articles of War, and with the provision that such court shall not lose jurisdiction over the case even after the discharge from active service. So the purpose is to accommodate the suggestion of Secretary Teodoro that they should continue to have control over a military personnel even after they have been discharged. But of course, I leave that to the sponsor. He is amenable.
Madam Chair, there will be two jurisdictions, Articles of War, and that's the military, and civil courts. So therefore, they will be tried by both. We cannot exempt military personnel but not facing this case of espionage in court with these penalties. Because then they can also, at the same time, that's always like that. When Nino Aquino was charged with the father of El Jokno also as lawyer, there was a military commission. It was Marshal Loyone. But then, if it is, but the civil court, there was a question because the civil courts were functioning. And so therefore, things like those should be, rebellion or so forth should be with the courts. But then, it was the military commission. But in this case, we are in a normal state. And so, there will be hearings, there will be cases filed against this military personnel in court. At the same time, the military will not lose jurisdiction over the Articles of War, and they will continue to also hear. So theirs kasi will be dismissal. That is the ultimate dismissal. And then they will be dishonorably discharged. That is the court-martial that can happen. So therefore, military officers shall likewise, to be able to make sure that we follow Congressman Panaligan's, shall likewise be tried, shall likewise maybe shall likewise be tried by the General Court Martials under the Articles of War. So there will be two jurisdictions, separate jurisdictions. Is the Honorable Panaligan agreeable
I defer to the wisdom of the
to
committee.
put shall likewise? Because clearly they are already liable under this new espionage law.
Yes, I submit to the...
So to not to oust also, so clearly shall be tried by court martials. Kasi mga additional ito eh.
even after they have been dismissed, assuming they are no longer in the service.
Yes, they will continue
They
to
will
face the
continue,
civil
yes.
case.
That's the concern of
So
Secretary
mabilis
Teodoro.
itong kwan eh.
Yes.
They will be liable with the court case.
Yes.
Even if they're discharged. Because the objective of the Articles of War is to remove them dishonorably discharged. But the courts will put them to jail with then accessory penalty. Public officials sila cannot hold public office. See.
Thank you, Mr.
Madam-
Chair.
Thank you. Thank you, Madam
Thank
Chair.
you, Chair. Thank you, Kong Nifus. Any further comments?
Madam Chair,
Yes,
I
Representative
think
Mercado.
we need to put up another paragraph to implement the position of the Honorable Rodriguez. Because under the present bill, military officers and personnel charged with violations under this act shall be tried by General Court Martial only, not by the court.
We will insert
walang
the word.
likewise eh.
We will insert po the word likewise.
Okay.
Thank you.
Thank you, sir. Yes, Attorney Arcilia.
To answer your question, the earlier question regarding the juridical entity, from what we know is that there's an active cyber espionage conducted by an APT. Although the APT that our cyber intelligence directorate have identified are all located outside the territorial jurisdiction of the Philippines. But with the inclusion of our extraterritorial application, I think those group of persons or entity may already be prosecuted, charged here in the Philippines. So that's one of the example we know of juridical entity conducting espionage.
But my question is, Madam Chair, with your permission.
Go ahead.
There is also a company in the Philippines with Filipino incorporators. There is. The NICA should know this. So not only Coast Guard, but the NICA should know this. Where is this located? This agency, this particular corporation? Ayun.
From the revelation of Senator Tolentino, it's Infinitus, the one in Makati.
That's what I have read. I just came. Infinitus, infinitesimal, infinitus. See? So we have to make sure, these people who are the president, chairman there, when this will be approved, ayan, magtago na sila sa China. Okay. Thank you, Madam Chair.
Thank you, Attorney
Infinitus.
Arcelias. Okay, I think we have gathered enough comments on section 13. Can I get a motion to approve the section subject to the amendments earlier made, subject to style, of course?
Motion to approve.
We have a motion to approve, which has been seconded. Section 13 is now approved. Section 14, designation of prohibited places by proclamation. Any comments, please? I think this is not controversial section, but if there is a wording that you may want to propose, go ahead, Colonel Abesa.
When we say proclamation, are we going to publicly announce it that this particular place is prohibited? Baka, ma'am, instead na it would do good, it would do harm, considering that would definitely, if you're going to flash it to the public, it would already invite attention.
Chair, it's already clear. National defense assets. Definition, alam na natin kung ano yung assets. Which are buildings, grounds, mines, missile launch facilities, data centers, all of this is under definition, paragraph E, I. And also I2, defense materials and defense utilities. So you don't need to announce it, Madam Chair. It is in the law itself. So that's right.
Thank you, Madam Chair. On a separate matter, Madam Chair, may I respectfully suggest the deletion or on the phrase or the Secretary of National Defense. I think the earlier sentence, the President or the President's duly authorized representative already suffices. And I think any pronouncement by the SND is pursuant to the Commander-in-Chief powers also of the President for this purpose.
Thank you, Co-Chair. Yes. Do we have comments on that? Chair Rufus, will it be amenable
What
to
again is
accept?
the proposal?
The proposal is to remove Secretary of National Defense, considering that it is already...
I think it's very important because in itself, the or here, the conjunctive or, is preceded by a comma. And so in himself, the Secretary of National Defense may designate prohibited areas, aside from the right of President. The President is very busy, and he has, of course, he may also designate for other critical infrastructures who will designate the prohibited places. So therefore, we need to have the Secretary on its own. He may not be designated by the President, no problem, but he's the Secretary of National Defense. So that's why we included him here, so that on his own, the Secretary of National Defense can therefore be able to designate prohibited places where military classified activities, matters of information are there. So that is our view on this.
Madam Chair.
Sir? Okay, Representative Mercado first.
Thank you very much, Madam Chair. Yeah, I think what the good gentleman is trying to propose here is selective places, Madam Chair. Of course, we have critical infrastructure, but when it comes to prohibited places where military or classified matters of information relative to defense and national security are concerned, I think we should not allow it to be publicized for security and confidentiality reasons. So I move that we provide here except prohibited places where national or military activities, matters of information relative to defense and national security are exempted.
I think there's a little confusion because of the word proclamation, and maybe the word designation would be better just to clarify it. The word proclamation does not necessarily mean that the President or anyone will publicize the designation of these prohibited places, but maybe just for clarity, we can remove the phrase by proclamation.
Yeah, they can designate, Madam Chair, but as far as this classified matters of information places where it will be preserved should not be publicized.
Okay.
Because
Madam Chair, I agree with Congressman Oging here that without need, hindi na yet gamitin natin proclamation because even Section 14 title is designation.
Yes.
But we will be silent on not to be published. That is something for the agencies to determine, those in the critical infrastructure. But this one is about defense, very clearly, military or classified activities. So I agree, instead of proclamation, because it brings the idea, it will be proclaimed to the whole world. The meaning of proclamation here, the President writes a proclamation That is why mali naman kasi designation lang. Oh. So, I agree without need of such designation. That will be sufficient.
Okay, thank you.
Madam
So-
Chair?
Yes, go ahead,
Sorry.
Co-Chair.
Just seeking for a compromise for the statement on the SND with the good proponent, Manong Rufus.
Yes.
I think the power to designate places like this should emanate from the Commander-in-Chief. And may we request as a compromise to change the wording into, as the President's duly authorized representative, the Secretary of National Defense instead. Because I think designation should always come from the Commander-in-Chief. And the SND is acting in representation of the President when he designates certain areas.
The thing
Not by
is,
himself.
there will be other designated representatives in other critical infrastructures. That's why we have here a general phrase for the President's duly. I would like to repeat that there are many critical infrastructures mentioned in classified materials. And so therefore, we say that if we will just say the duly authorized representative, the Secretary of National Defense, it will limit the President. No? So the President may in other infrastructure, but in himself, the Secretary of National Defense being in charge of our national security and defense would be the one that may also designate. That is the reason why we have the two phrases, the President or the President's duly authorized representative or the Secretary of National Defense, especially on defense sites.
Go ahead. Yes.
Sir, I would propose that the Secretary of National Defense shall be amended to the Secretary of National Security Council, which the Council is a representative of all government agency.
Director Batle.
The National Security Council serves as the secretariat. So usually po, the National Security Council ang nagkukonvene ng Presidente, but he can designate the ES to convene. So ganun po. It's hindi po siya regular na kinukonvene. So I would recommend po na si SND na po kasi department po siya. Ibig sabihin, specific po siya. Unless kung ilalagay po natin is the National Security Council, mahirap po siya i-convene. And usually po, the President will convene the National Security Council. Thank you po.
Thank you, sir. We
Yes, it should be. Mahirap yung council eh. Council is a policy-making body recommending. It does not do executive functions like the Secretary of National Defense. So directly na, so that medyo diretso.
Okay.
Secretary Gibo will not like your suggestion. So, can we strike from the record because he might be, you're diminishing the right of your head. The Secretary of National Defense. And so we'll just have that passed. Yeah, thank you. So we'll retain
Thank you. Okay.
National Defense. Okay, now.
So, do I have a motion to approve Section 14?
Move.
So move. Do we have okay, the motion.
Madam
has-
Chair, just a
Yes?
minor grammatical correction. Section 14, no? We insert the word or between prohibited places where military or classified activities or matters of information,
Oh, yes.
etc. Yeah.
Thank you. So we have a motion which has been duly seconded. We will approve Section 14, of course, subject to style.
Madam Chair, let
Yes.
me just put into record, I think the NICA gave this to me, this piece of paper. The Coast Guard, good that you have made your research. The name of the corporation is Infinitus, with the U.S., with U as capitalized, Infinitus Marketing Solutions Incorporated. Founded in 2018 by Paul Lee and Micah Baseo, based in Makati, for the record. This is the example of a company which will be liable once we have this particular law approved. Thank you, Madam Chair.
Thank you, Chair Rufus. We note the name Infinitus with the capital U. Section 15, classification and custody of classified matters during inquiry, investigation, and prosecution. Comments, please? We have a few sections left, so I think we can finish this today. Section 15. Okay. While I was reviewing the draft and making some edits, I noted that the last sentence of paragraph 1, which states, such classified matters shall be handled in accordance with the existing and subsequent guidelines in the handling of classified matters, and shall only be accessible to individuals with the requisite security clearance and on a need-to-know basis. The question I raised with COMSEC then is, do we have these guidelines? So based on the discussions earlier, I guess it would be those EOs or circulars, right? Do we have any comments on this section? If none, I will solicit a motion to approve the same.
I move to approve.
Okay, there's a motion to approve. Thank you. There's a motion to approve, which has been duly seconded. Section 15 is now approved. Section 16, surveillance of suspects and interception and recording of communication. I solicit your comments on this section. Yes, Attorney Arcelius, go ahead, please.
Thank you. May we request, if that's okay with the body, to lower the, instead of Court of Appeals, we go to the Regional Trial Court for the wiretapping order. Thank you.
Sir, our proposal in the AP is as a compromise. Probably the default court is the Court of Appeals. But however, in case of exigency, and usually the RTC are the immediate courts available, it should be the RTC. However, the applying unit would somehow report it to the Court of Appeals. So there are two courts. The default is the Court of Appeals, and in cases of exigency, the RTC.
Colonel, why do we want the Court of Appeals to be the...
I think, sa totoo mas mahirap. But however, for safeguard purposes, I think mas maganda for Court of Appeals. Mas madali pag RTC kasi sa land judge and nandun lang sa area. But for the purpose of safeguard, mas magandang RTC, CA, but however, we should also give the power for the RTC to give order, provided that they will inform CA.
Okay, so when do we go to the RTC po?
In case of extreme exigency.
Such as?
Wala na kasing time. Usually, ma'am, walang ng time for the purpose of surveilling or intercepting. Baka wala ng time ang isang unit to survey or to intercept. If the unit belongs to Mindanao, malayo na yan for us to apply for a court order.
Madam Chair,
yes.
When we talk about wiretapping, this is a threat to right of privacy of everyone. This can be used not only because there is espionage, it might be espionage on political affairs. So what we are saying here, any kind of diminution of rights of individuals to be secure in their conversation, we need a higher court, like the AMLAC, for example, Court of Appeals, because it is really a very, very important right of an individual not to be intruded upon through wiretapping. And that's why we place here Court of Appeals. And Mindanao, don't you know, Colonel, that there is a Court of Appeals in Cagayan de Oro, my city, the city of golden friendship? Unreachable by the north, the south, east, and west. Very, very central. So that you can file there, ex parte application.
Chair,
Cebu, nandyan din sa city. Cebu.
I attend hearings in CA.
See, that's why we
Cagayan.
like our chairman because she always comes to Cagayan de Oro.
Yes,
It's
sir.
our favorite. So, let us leave it at Court of Appeals because ito nga, I'm sure that Attorney Diokno will not agree to just any RTC. Delikado tayo dyan. Baka tayo ma-wiretap. O yun. Diba? So, that is what we would like to have. Court of Appeals tayo, Panyera. Kasi that is a higher form na medyo there is always collegiality. Tatlo yung members sa Court of Appeals eh. Ito isang judge lang sa RTC. So I would suggest that we retain. And please come to Cagayan de Oro. We'll treat you to lunch there when you file an ex parte application.
Yes, sir. Actually, sir, I'm also
Thank you.
came
Thank
from
you very much.
Cagayan
Thank
de
you.
Oro, sir.
Yeah.
De Oro po siya.
You did not identify yourself earlier, so that could be very kind with you. Kinder. What is your family name?
Dapanan.
Bulwanas. Anong barangay ka?
I'm from Bulwa, sir.
Bulwa?
Yes, sir.
Oh, that's really our city. So thank you, paisano, ha? May kababayan. Thank you.
Okay. Okay na.
Madam Chair.
Yes, yes, ma'am.
I understand. No, I'm from Zamboanga City. Sí. Buenos días, señor. So, may we register our suggestion to really do it in regional trial court because especially for operators like the ones in far-flung areas, including the Basolda areas, may be really it may be really difficult for them to apply for a court order from the CA. Also, there are safeguards in the law itself, which requires, of course, the authority from the head of the agency and not just the unit where the applicant is coming from. And there are that's it. I think there are safeguards for against abuse. Thank you, Madam Chair and Kong Rodriguez.
Okay. I understand where the both of you are coming from. So we have the CA side, we have the RTC side. Can we come up with a compromise? So we will have the exigencies as stated. Maybe we will include that. When there is a time
I would propose, ma'am, that
constraint,
subject to
distance.
period within certain hours or within a certain days, it is a temporary order coming from the RTC, not the exact order. That order from the RTC shall be subjected for a review coming from the CA.
Madam Chair, I
Yes,
think
Go Chair.
this topic requires also the comment of the judiciary because it might expand the jurisdiction. So maybe it's a good time to adjourn and have lunch first and wait for the comments from the judiciary.
But working lunch will be okay. As we usually do, not, no? So I think we insist on the CA because the danger, yung exigency in extreme circumstances, who will decide that? It will be the military and the police at the expense of civilians. So I think, diba? It should be the CA to prevent.
E-filing na din ngayon, di ba?
Sa CA na tayo. Yung basulta, you can apply in Manila. You know, the NICA is here, the DND, they apply here. Because Tawi-Tawi can be reached by Philippine Airlines. You see? Yeah. Philippine Airlines goes to Tawi-Tawi, one of the most peaceful provinces in our country. I've been there twice and I eat a lot of seafood there. So, if that is the case, it has to be here. We have to limit, Madam Chair, not just anybody, RTC, ang dami nila. So, to
the
protect the
lawyers
rights, yeah.
in this room, correct me if I'm wrong. We already I haven't filed myself in the past several years, but there is e-filing already, right? So we can make electronic applications, file pleadings to the CA before the CA through e-filing. Is that correct, sir?
Yes, Madam Chair, that is correct.
Not all courts have already e-filing. It's still a project that is being done by the Supreme Court. CA is at the Supreme Court. So is all the other courts, CTA, and then also Sandigan.
CA has e-filing.
Already?
Yes. Yes, it's mandatory in all courts na po. Okay, in that case, we retain.
Yeah, so therefore, the more, it should be CA because it can easily be filed electronically. The ex parte application, which is found in
Section 16.
Yes, in section
16.
131 of section
Okay.
16. Yeah, so that's more reason why we should allow only the court appeals.
Okay, so section 16, do I have a motion to approve?
Mr. Chair,
Madam
I
Chair.
move to approve.
Thank you.
Madam Chair, I'm the author of this, but I'm now not very much at ease with having the NTC receive a copy of the application.
Okay.
Can we have, what are comments on,
Yes,
tayo to
sir.
already furnish the NTC at the very first instance about the application. Mahirap na yun kasi these are matters of national security. May we know our
Yes,
positions?
Colonel Abesa.
Ma'am, from our understanding, the application here is not, in the submission of e-filing is limited to pleadings and processes. But it's not for, the section 716, sir, would be an application for a search warrant. It's similar to a search warrant. So in that case, usually, sir, in the chambers lang ni Judge, sir, it's not a usual e-filing. So I would suggest, sir, if not CA, then probably we could have a dedicated or designated courts, considering that, understandably naman, these proceedings are not your typical criminal type proceedings. So it's limited to more or less certain individuals which are cleared by to take possession of classified matters, including judges and prosecutors.
Okay, I understand, sir. Earlier, we have a motion. Can we approve this in principle, and then we will accept the different wordings and
The author insists on the Court of Appeals to protect our people. So it will be Court of Appeals.
Okay, and we have a second on that motion. So section 16 has been approved, subject to style, of course. Section 17, authority.
Madam Chair,
and
ito
your
yung
NTC comment.
I was asking, so we go back to section 16. Itong NTC, are our resource persons comfortable with giving a copy of the application to the NTC? There will be another one that will know about this wiretapping.
Actually, sir, the order is coming from the court. We should furnish the order to the NTC to comply. So the NTC would somehow require all ISP provider to give the information.
That is after the fact, but here it is to furnish with said application, the ex parte application. I don't mind the Court of Appeals telling later on. Pero na-issue na. So that may secrecy rin against these people. Kasi may mga targeted people ito eh. Kung may other people that are involved, like NTC, it can be, leaked to these people.
Okay.
So, can we just change the furnish the NTC with a copy of the approved application? Yeah. So, subject to style shall be, and then the NTC shall be notified by the applicant law. So, in other words, only after the fact. So, that nandyan na. Then we involve
Not
them.
the application
But before that,
itself.
mahirap.
Okay, so Section
So wala tayo-
16
Okay.
has been
Amended.
approved as amended by the
Yeah,
proponent.
okay.
Thank you very much. Section 17,
We copy
authority of the AMLA.
Madam Chair, may I?
Yes.
I think the reason why the mere application will be furnished to NTC so that all the metadata will already be intercepted or recorded by the NTC. Although there's no authority on the part of the NTC to immediately provide the information that they will collect from a certain phone numbers or a certain account, I think the transmittal or the furnishing of this information will come only if there's already an approved order. But the NTC will now start the recording or preservation of the metadata that will be transmitted using the account that they are targeting.
Okay.
Your Honor, or another recommendation as to limit the possible leakage of such document, if it's possible that instead of just writing NTC, we could directly, or just the commissioner of NTC should be the one be given the copy. Thank you, sir.
Yeah, I agree with that. But the furnishing, it should be the order. Kasi tapos na eh.
The order
May order
approving.
na. Pwede namin kasi mabilis ang military dito eh. Pagka may order na, wiretap na, give notice to ano. So it should be furnish a copy of the
order
ex parte order of the Court of Appeals and to be addressed to the commissioner. So tama siya, isa lang. To the commissioner of the NTC. Not to the office of the NTC, like the office of the Secretary General of the Court of the Congress, the House of Representatives. Yan. Okay?
Mr. Chair.
Okay.
Madam Chair,
Yes,
sorry.
Director Navarro.
Madam Chair, perhaps the applying unit may request the CA to issue a preservation order. And that preservation order can be immediately, meaning before the directive from the CA, Madam Chair, is issued to the NTC. In the interim, so what happens while awaiting the CA action? So perhaps the preservation order can be availed of.
To preserve what?
Preserve the data, yes, the records, Mr. Chair. But of course, this is of course another incident wherein a possible operation security may arise. So I think this has to be balanced, Mr. Chair, Madam Chair, with the exigency of the operation po.
Madam Chair, everything is on hold until there's an order. The operative fact is the order of the Court of Appeals. From that time on, it is given, immediately there will be wiretapping. At the same time, there will be a copy given of that, so that there will be, in that order, preservation of all the records. Okay, so it will be after the fact. Because if we will put preservation first, alam na ng may NTC na, ito pala, target na ito. So mahirap yun. And then presuming na tama, presumptuous na mag-grant yung ex parte. So ganon yun ang
We submit, Madam Chair.
Okay. Thank you very much. So we approve Section 16 as amended. Section 17, authority of the AMLA.
Raising of hands of Colonel.
Yes. Colonel Abesa.
Yes, ma'am. Thank you, ma'am. I think the draft bill, ma'am, already provides for a IRR. So probably the details and with respect to the procedures and intricacies would be provided under the IRR. Thank you, ma'am.
Thank you, sir. Section 17, any comments?
Madam Chair,
Yes.
just minor omission of, minor correction lang po to remove the word interference.
espionage and interference in any forms hereby Any other comments? Yes, Attorney Aspiras.
Thank you, Honorable Chair. From the Department of Justice, may we request on the third paragraph on which reads the AMLC also may enlist the assistance of any branch, department, bureau, office, or agency or instrumentality of the government, including government-owned and controlled corporations, in undertaking measures to prevent financing of foreign interference. Can we replace it with financing of espionage? Thank you, Madam Chair.
How about or support to foreign intelligence? So, if we are okay with Section 17 as amended,
There is a proposal to remove interference.
Yes.
But precisely our bill enumerates the acts, and the act of destruction, interference, and obstruction is separate from espionage. And so we have to make sure that kung espionage lang interference, it will not be comprehensive to include all the other acts here. Okay, like, for example, it is destruction, interference, and obstruction. So it will not be able to get those to be under AMLAC. Because under the principle of nullum creme nullum pena, sine lege, then we are stuck to only espionage. So then they will say, hindi kasama yung Section 8, hindi kasama yung Section 9, Section 10. So espionage and other acts, can we put here, as amended, espionage and other acts prohibited by this
act.
Prohibited and other activities prohibited by this act. So that, kompleto. Lahat sila. Maski yung nag-aabet ng crime, sama rin. Kasi yan ang mga abetting, mga so forth. So, I would suggest espionage
and other crimes
other prohibited acts, other prohibited activities under this act. Ayan. So that will be more encompassing. Kasama na sa AMLAC. So move, Madam Chair, for that amendment.
Okay, do we have a motion to approve Section 17? Thank you. We have a motion to approve Section 17. Do I hear any comments, objections? A second? Second. Okay, the motion has been seconded. We approve Section 17. Section 18, forfeit.
Before we leave 17, now, do we have safeguards here that it will also state again that it will be an application in the Court of Appeals? Well, itong Court of Appeals So AMLAC can just include the espionage. So there has to be, AMLAC normally goes to the Court of Appeals. We know, Madam Chair, the position of the chair.
AMLAC goes to Court of Appeals for the purpose of freezing assets. But for the purpose of conducting financial investigation, they can conduct it on its own or upon the request of NSC or other departments.
Yes, but AMLAC, before freezing account, that is the right of everybody to have a deposit. So there has to be a statement here about the Court of Appeals, because otherwise they might just do this immediately, especially that there is a law on secrecy of bank deposits. Right. To inquire upon, the AMLC is hereby authorized to inquire upon application and approval from the Court of Appeals. So that will be clear. Hindi madali din ang CA pa rin. Like all of these flood control. Upon application and approval of the Court of Appeals.
Madam Chair, may we just ask, maybe from our agencies, if they have applied before? Because I think there's an AM resolution covering application for freeze orders that's already requiring that it has to go through the CA. So may I just ask if they had the same experience, so that maybe we don't have to add the wording?
Yeah, we have experience with terrorism cases, but I think the AMLAC has an authority to immediately, upon proving probable cause, to immediately freeze an account for 20 days. And then they use that 20 days within which to apply for permanent or for an extension of the freezing of assets for another 6 months if approved by the Court of Appeals.
So just for clarity, the process is ex parte, 20 days,
Yes.
subject to hearings, submission of papers, and then they will determine if the 6 months will apply or permanent.
Yes, but I think within that 20 days, the owner of the account can already file a motion for defreezing.
To lift-
I don't know
to
the
lift
word.
the freeze order.
Yes.
So, Manong Rufus, may we ask if your intention is to remove this 20-day initiative from the AMLAC, or do we follow the current practice in status quo?
I would rather that the same procedure with the first CA that we have. Application, and then let the CA decide to be able to have this particular order to freeze on those involved in espionage. So therefore, just statement upon application in the Court of Appeals, ex parte application of the Court of Appeals. So we have to mention again the Court of Appeals because that's a protection. Kasi if i-freeze na naman natin ang mga assets in the banking financial system. So just statement there upon application. So it may inquire. I will read the correction, Madam Chair, the amendment. So it will say that the AMLAC, so that subject
The AMLAC is
dito
hereby
tayo sa kwan.
authorized
Dito
to inquire
to authorize to inquire, that is the fourth paragraph.
or examine
Inquire into
deposits,
upon application.
investments, upon application with the Court of Appeals.
Court of Appeals. Okay. Subject to style, Madam Chair.
Yes.
So that clear tayo na CA pa rin talaga lahat. Protected.
Thank
lahat.
you.
Okay.
Madam Chair.
Yes.
I think the reason for that 20-day immediate freezing, I think to deter or prevent the account owner from, moving their funds. Anyway, they have, it's just 20 days. And then they can contest such freezing action. And they can already they can already participate in the process or in the proceedings in the CA.
We can have that in the IRR. In other words, the proceedings of how many days will be in the IRR, following what is being done now. But we have to mention already the Court of Appeals.
Yes.
So the IRR will mention this detail of 20 days, freezing, then you have 60 days to be able to question. Okay. So, Madam Chair, so that will be sufficient to mention the ex parte application to the Court of Appeals.
Okay, we proceed with Section 18 for feature of materials and effects. Any comments? Any suggestions? Yes, Attorney Calderon.
Your Honor, would like to clarify if the materials and effects directly used, intended to be used, includes fruits, for example, if information is being sold, so that it would also be forfeited.
Chair Rufus.
All materials. In other words, everything used for espionage will be forfeited to the estate. So all.
Do you suggest that we include the wording, the word fruits to...
What is the suggestion?
Intention, Your Honor.
To include the word?
Fruits.
The effects, the proceeds.
Well, it's already here. all the materials and effects. The effects includes the fruits. So all effects should be included.
Thank you. Any motion? Move. There's a motion to approve Section 18. Do I hear a second? Second. Section 18 has been approved. Section 19, liability for use of information and communication technology. Section 6 of Republic Act 10175 shall be applied in case of any of the offenses defined and penalized in this act is committed with the use of. If there are no suggestions, can I solicit a motion? There is a motion to approve Section 9.
There's a raising of hands.
UP law. Okay. Attorney Silva, go ahead.
Hello, Your Honor, Madam Chair. Thank you very much for recognizing us. Insofar as Section 19 is concerned, just a query, Your Honor, because we know that Section 16 only mentions the warrant to intercept communications. However, this mentions the Cybercrime Act, which actually allows for 4 kinds of warrants, for example, cybercrime warrants, in addition to the preservation order, which was earlier mentioned by one of the present order. May I ask if it would be the intention, Your Honors, of the author and of the body to include also the cyber warrants of the Cybercrime Act as among the warrants that may be obtained for the purpose of the espionage surveillance? I ask this, Your Honor, because while it mentions interception of communications in Section 16, the Cybercrime Act also allows for cybercrime warrants for accessing storage devices as part of intercepting getting communications which are already finished and completed. So perhaps, Your Honor, since Section 19 already mentions cybercrime, perhaps maybe it could be mentioned as well that the warrants allowed under the Cybercrime Prevention Act are also applicable in case of espionage-related offenses, Your Honor, or some such effect, in order to ensure the broad application of those warrants as well for this purpose. As earlier mentioned, they mentioned preservation order, which is used under the Cybercrime Act. Perhaps the others could also be used for the consideration of the
Thank you, Panyero. Madam Chair, I think we should read now Section 6. This is the problem with citing a section which I have not read, although I'm the author. What is Section 6?
I believe it elevates the degree of the offense. Yes, sir.
Section, because we are saying that there's an application of Section 6 in cases penalized in this act committed with the use of information communication technology. So what is Section 6? To clarify to everyone.
Mr. Chair, I may volunteer to read the particular section from CICC, Mr. Chair. Madam Chair. Section 6 of RA 10175 reads, all crimes defined and penalized by the revised penal code as amended and special laws if committed by, through, and with the use of information and communications technologies shall be covered by the relevant provisions of this Act, meaning RA 10175, provided that the penalty to be imposed shall be 1 degree higher than that provided for by the RPC as amended and special laws as the case may be.
Very clear. So there will be additional 1 degree higher. So for government officials committing this, higher na sila, mas higher pa. I agree. So Section 6 very clear. So we'll just use that. Section 6. The reference was very clear. So it will be 1 degree higher. That's the import of Section 6. If you use, ICT. Okay. Thank you. So okay na ba? Attorney Silva of UP Law Center, my favorite law center. Thank you. Okay.
Thank you, Chair.
Okay na yon.
It's my favorite law center too. Okay, Section 19. There's a motion to approve. There is a second. We approve Section 19. Yay. Okay, we go back. The remaining sections are the usual provisions that we add. We go to section.
Madam
Let's
Chair.
go to Section 2, Declaration of Policy.
In
Yes,
Section
ma'am.
20, Madam
Section
Chair,
20.
may we request that the the primary agency responsible for formulating the IRR should be the DOJ, and then the DND and other government agencies under the executive will only assist the DOJ.
DOJ, are you okay with that?
No objection from the Department of Justice. But since this involves national security matter, we suggest that it be chaired by the Department of National Defense. DOJ can co-chair or the vice chair. So we will fully support this. Thank you, Madam Chair.
Okay.
The part
Yes.
of the AP, ma'am,
On the
I would
part-
suggest that considering that this law shall be applicable to all agency, the drafting of the IRR shall be led by the NSC, and the membership thereof are the members of the National Security Council.
Okay. I think that makes sense because all of you are part of the NSC. Okay, thank you. NC. So, Section 2, Declaration of Policy. Do you have any comments on that? Excuse me. These are policy declarations that we got from the Constitution and general laws. If there are no comments on Section 1, Section 2, can I get a motion to approve these two sections?
Motion to approve.
There's a motion to approve. Second, Sections 1, 2, and 2 are approved. Let's go to Section 4 before the definition of terms. Extraterritorial application. Kindly go through.
Madam Chair,
Yes,
just a
sir.
clarification. Are we now tackling Section 3, definition of terms, letter A?
Kong Diokno will go first to Section 4 because for the definition, I think they
Thank
can
you.
propose the definition of the different terms.
Thank you, Madam
Maybe
Chair.
we will approve it in principle and then they give us the definition. So Section 4, please, extraterritorial application. Do we have any comments on that? Yes, ma'am.
Madam Chair, just a minor comment on the last paragraph, especially on the proviso that in the absence of any request for extradition from the state where the crime was committed or the state where the individual is a citizen or national or the denial thereof, the National Security Council shall refer the case to the Bureau of Immigration for deportation or to the DOJ for prosecution in the same manner as if the acts constituting the offense had been committed in the Philippines. Currently, our mandate under the Administrative Code of 1987 is formulation of policies. So this might entail some additional funding if we are going to be given the task of referring cases to the Bureau, since we don't have yet, at least not yet, a unit that would to look into the cases to be referred to the Bureau of Immigration or to the DOJ for prosecution. That's a minor observation on the part of the obligation on the NSC.
Understood. Because as a council, you're tasked to formulate policies
Yes,
in
and
general.
the NSC is supported by the National Security Secretariat, which is as a support to the NSC proper.
Yes. So, sino po dapat ang mag-refer sa BI? PNP? Chair Rufus, do you have any comments on that? Yes. Chair, the lady suggested that maybe it should not be the National Security Council that will refer the case to the immigration if funding. Wala silang funding para
Madam Chair.
Question po, Madam Chair. I know I might be too late in the day, but I would just like to float the question, not really. I know it has been approved under Section 17, but I just want to float the question only if the request to AMLC to authorize, if the request to investigate is limited to NSC, or if we are open to adding other agencies who may request AMLC to investigate. But I know that this has already been approved, so I just would like to float the question po.
Thank you.
We're finished with that section, so we are now in section 4. So you were saying for section 4 that you will be out, the National Security Council.
We are not totally saying that we are out, but what we are saying is if we are going to be given the task of referring cases, since generally under the admin code, we are limited to formulation and coordination of policies. If we are going to be given the task of referring cases, this might entail establishing a unit, which might entail additional funding for us.
Resolution from the state.
Chair Rufus, what do you suggest?
Still, I
Yes.
could not really. Crime was committed. So command was committed. State was as divided citizen or the nether of the nations.
So the crime is committed outside
In the absence.
by a foreign national, not
Because if there is no request, then there's nothing to act upon.
Do we need this? Do we need this paragraph because the person is abroad? So there's no sense for deportation.
Madam Chair,
Yes.
I'm just trying to
Congressman.
understand the last paragraph.
Yes.
Would it be in our interest to actually prosecute the foreign national here?
Okay. Chair
Because it's
Rufus,
saying
the idea is first there's a foreign
Foreign
national
national.
Who committed the crime abroad.
abroad. Okay, so he's
Yes.
abroad.
So, first, since he is abroad, we cannot deport him.
Right, but
So
why is there a
we should
reference
remove
to?
this portion.
Yeah, that was, I think, threw a wrench on
Yes.
my thinking. Why is there a deportation when?
he's abroad.
Yes.
Madam Chair. Madam Chair.
Yes.
I think this paragraph refers to individuals who have committed acts of expenditure, or any acts under the bill that falls under any of the six conditions. Six conditions, which are those committed outside the territorial jurisdiction, but against the Philippine authority or Philippine officials.
Like an airship,
Yes.
embassy.
Madam Chair, I actually take back my what I said earlier. I think this contemplates foreign national committing prohibited acts abroad, but happens to be in the Philippines. Like so, we have jurisdiction.
jurisdiction, but
here.
It shouldn't be
It shouldn't be deportation because
there.
it wouldn't be in our interest to actually deport that person. We would rather prosecute that person.
We have to bring him here.
He's here because it says
No, this extraterritorial application, so it's committed outside.
only when such individual enters or is inside the Philippines, inside the territory of the Philippines. So he is physically present here. So the proviso is saying that if there's no extradition request from his home country, that we should refer to the BI for deportation or to the DOJ for prosecution. My question is, why would we want to deport him if he's here? Wouldn't we want to prosecute him? There is no extradition, so we are not obligated to deport him. But he's subject to jurisdiction of Philippine courts. Yes.
Yeah, Madam Chair, under our principle of territoriality in the revised penal code, Article 4, it is clear that we can only make persons responsible if they are in our territory. That's the first rule. That's why numerations A, B, C, and D are really Philippine territory. You will see this. B, inside Philippines, number C, onboard Philippine ships, and then in our embassy consulates. Okay. But the general statement, since they are Filipinos, they can be reached abroad, is under question. Because if they do it abroad, territoriality, it will be when they return. That's why meron na catchphrase dito. That is for A, E, and F. In case of an individual who is neither a citizen or a national of the Philippines who commits outside the territorial limits, we can only exercise jurisdiction when such individual enters or is inside the Philippine territory. That's the time it will go on. So the case will be filed against a Filipino committing it abroad, no? Because joining the espionage abroad. But then, a case will be filed here, it will be archived because they cannot be arraigned. And when you are not arraigned, no jurisdiction attaches to the person.
But when he returns, then there can be a motion to already again arrest and we'll be able to arraign the person. So I would suggest that we follow the articles, the rules of territoriality. Here there is extraterritorial,
meaning that I'm not confident even on extraterritorial application. We cannot apply extraterritorial application under our laws because ours is territorial. And B to D is Philippine territory. Yung A, okay. And then EF, wala. If they're abroad, wala. You cannot really proceed with the hearing because they will not be arraigned. But when they come here, that's why the catchphrase here is that when they come here, then they will now be subject to Philippine territory, to our rules, because they committed all of these acts. Okay. So therefore, we just have to remove itong very confusing after the statement about the Bureau of Immigration and so forth. So what will happen now is that it will end or is inside the territory of the Philippines, period. So remove the proviso. So in case of individual who is a citizen, once they come here, then they'll be liable because they are now in our jurisdiction and they have committed one of the crimes as stated in the act. So would you be agreeable with that, to get this out?
Agreeable. Yes.
Madam Chair, I agree. But what about in cases where there's a request for extradition?
We have an extradition
Then
law.
we will follow the extradition.
That, we don't really care because we want them here. Yung extradition, they want to bring them out. No, we will maintain them here and imprison them here.
So we're honoring the extradition treaties,
Yes.
but we are not mentioning it here.
Yes.
Yeah. Because they comply with the extradition law. Those we only have extradition treaties. Those are the only people whom the country can request to be brought there or tayo to be brought here.
Okay.
So just a period, Mr. Chair, that
After
to have the after Philippines period, no more proviso.
Remove the proviso.
Proviso no more.
Okay, Section 4, do I have a motion to approve? Section 4 as amended.
Madam Chair, just minor suggestion
Yes.
regarding paragraph C, D, and E, and F. Can we just state two persons rather than individual persons? After all, we have
Correct.
already defined in the previous section, Section 3, that a person refers to an individual, partnership,
Yes.
etc.
Thank you for that. Minor lang po. To remove individual.
No. Section 4. Letters D to F. We remove
Just
the term, the word
the-
individual.
Just the word individual before persons.
To persons, so it will read to persons who, although physically outside territorial limits.
Yes.
Thank you. Okay, Section 4 as amended. Is there a motion? Yes,
Move to
there's a
approve.
motion. And do I hear a second?
Second. Thank you very much. Section 4 has been approved. Section 3, definition of terms. I believe this is a section that should come from the resource persons. If I can solicit a motion to approve the section subject to the terms that you will add or further define, and maybe we can approve this section.
Madam Chair.
Yes,
Yes.
no.
May we know if the proponents would be willing to accept some modifications to two of the terms defined in Section 3?
Go ahead,
Section
sir.
3A, classified matter, and Section 3D, national defense. I'm very concerned about the definition of classified matter as it is worded at present. And I would propose that we include the phrase relative to national defense at the end of the first sentence. Otherwise, we would not be giving sufficient legislative guidance, I believe, to whoever official will be given the power to deem sensitive whatever is considered as classified matter that would be equivalent to espionage. The amendment would go as follows. Classified matter refers to information or materials classified as top secret, secret, confidential, and restricted in whatever nature or form that the government or administrator of critical infrastructure deemed sensitive and requires protection from unauthorized disclosure relative to national defense. In relation to that, with respect to Section 3D, national defense, may I propose that we adopt the following definition. The term national defense refers to programs, activities, and projects aimed at protecting a nation's security, including military operations, critical infrastructure, energy production and distribution, stockpiling of essential resources, emergency preparedness efforts, and national defense assets, national security places, and prohibited places as defined below. So that at least we are giving legislative guidance to whoever officials will be in charge of this matter. Thank you, Madam Chair.
Thank you, Kong Diokno. Chair Rufus.
Again, the first one, Kong Chel, the first one you would like to include where after disclosure?
after disclosure.
To only be on national defense?
Well, relative to national defense, as defined in my next proposal, which I think...
With this, we can accept that, Madam Chair, because we are talking here of different critical infrastructures. And critical infrastructure includes not only national defense, but also we have national economy, public health or safety, the administration of justice, and other functions analogous thereto. So therefore, we cannot limit this definition of classified matter to only national defense. So that is my opinion on the proposal of Congressman Diokno. So what's the other one?
May we know if the Honorable Rodriguez would be, if I may point out that to the Honorable Rodriguez that as proposed, the national defense term is broad enough to include critical infrastructure, administration of justice, and the other matters that you had just mentioned. The reason being that I believe we need to provide, we cannot give the officials just unbridled discretion in terms of what they want to deem sensitive that would give rise to the offense of espionage. That's why I have twin proposals. We tie classified matter to matters. We give that discretion relative to national defense, and then we adopt a broader definition of national defense to include critical infrastructure, even emergency preparedness efforts, energy distribution and production, stockpiling of essential resources. That way, we cannot say that we are not unduly delegating legislative power to our executive officials.
Madam Chair, thank you, Congressman Diokno, but it's better to have a clearer delineation and clearer enumeration rather than lumping up all the others like national economy, public health safety into national defense and security. Because somehow there is always that particular connotation to what is national defense and security. By doing this, we are able to make our law more specific, and that will provide a clearer picture to the judicial authorities. So I would suggest that we continue with this, and national defense and security, the definition says broadening it will be just be this one. National defense refers to the mechanism of the state to marshal a nation's forces and resources to protect national interests and respond to threats thereof. So unfortunately, I cannot accept the proposal to lump up everything with national defense and security. So we have these different critical infrastructures provided here to assure that we are able to make sure that we are protecting our state from all of these critical infrastructure. So I think the others can also comment on the proposal of Congressman Diokno.
Yes, can we have your suggestions on the proposal of Congressman Diokno? Attorney Calderon, please.
Your Honor, I would have to agree with Representative Rufus Rodriguez. We shouldn't mix together defense and security. I think for security matters, it encompasses health, energy, economy, finance. But as to defense, it's more particular with territorial integrity and sovereignty. So I have to agree with Representative Rodriguez, Your Honor.
May I just respond, Madam Chair? The definition that I drew up actually is based on the definitions of national defense that have been adopted by other countries, which is now very broad. While the traditional definition of national defense only refers to territorial sovereignty usually, if you look at the laws, for example, of the United States and others, they have already broadened that to include even critical infrastructure, energy, emergency preparedness, because all of these also relate to national defense.
Just a manifestation, Madam Chair.
Yes, ma'am. Thank you, ma'am. I think, ma'am, the definition of the national defense and or national security has already been defined under our national security policy as issued by the NSC 2022 to 2028. But in the national defense, it only pertains to the protection of the state against the internal and external aggression from other threats. But on the national interest, it's a broad concept of policy. That's why it's issued by the NSC. But it pertains to the security of the people, the sovereignty, against all threats. So marami siyang domains that tackles the national interest. So basically, national defense and the national security are not the same, sir. So nandun na yung, siguro sir, ang reference natin dito is the national security policy.
Madam Chair, just to stay within the four corners of this particular page, we're not even talking about the bill. How about as a compromise, no? So the Section 3A in part reads, deemed sensitive and requires protection from unauthorized disclosure relative to critical infrastructure and national defense as defined below. Because if you look at the areas of concern, there are only two areas of concern in this bill. It's critical infrastructure and national defense. So that if you look at the definition of terms, you see repeated references to national defense, right?
National defense utilities, national defense materials, national defense assets, national defense. The other thing that is mentioned here, or is defined separately, is critical infrastructure.
So therefore,
I propose unauthorized disclosure relative to critical infrastructure and national defense. That way we preserve the definition that Kong Rufus is pushing, which is what's in front of us. And we also make reference to critical infrastructure. I think the concern of Kong Jokno is really to put an additional guardrail through insertion by inserting relative to. So relative to national defense, relative to critical infrastructure as defined below.
Madam Chair, I just want to complicate things further. Kasi po, the DFA is also using the MC78 in classifying the information with regards to foreign relations. So I think that also needs to be covered by the classified information. So if we're going to limit the definition to national defense and critical infrastructure, we will leave out the information on foreign relations. Thank you.
Any more comments before I go back to the proponent?
To me, Madam Chair, it's better to have the enumeration of what critical infrastructure is. And it does not pertain only to national defense or even national security, because there are important aspects of our country, example, national economy, public health or safety, the administration of justice. These are enumerated not because they are just simply important ones, but we are giving the fact that these are the focuses of this critical infrastructure. And then it may include, but not limited to. So the more we are particular, then the more there is basis for our courts to convict those who are really who are committing espionage in these different sectors, not only national defense. That's why I would rather that we continue with this definition, because it is clear. And then also what is national defense is also clear. And so also stated there. And then national defense assets is also enumerated, national defense materials. So we have a comprehensive bill that would guide everyone, all those who implement this law, and also those citizens or foreigners who are minded to commit crimes here. So this, to me, we continue with this definition, Madam Chair, and not to limit it only to national defense. Thank you.
Madam Chair,
Yes,
I think we can reconcile the definition of Congressman Jukno and Congressman Rodriguez, because our act itself is entitled expanding, so we have to expand. And the definition of Congressman Jukno aligns with the Section 2 Declaration of Policy, where information that affects national security or national defense. It does not mention only national defense, but it involves national security. So the matters mentioned by Congressman Jukno can be considered as national security matter, and the matter mentioned by Congressman Rodriguez can be considered as national defense requirements. So I think for purposes of focus and clarification, the definition of Congressman Jukno is more clear when it comes to alignment with our declaration of policy and the title of the bill. Thank you, Madam Speaker.
Thank you. Can I hear from Attorney Silva, please?
Your Honor, thank you very much. I was listening to the wonderful discussion, Your Honors, and may I note, perhaps it could be stated at the end of the first sentence of this definition, Your Honor, consistent with the fact that we have MC78, EO608, as well as Memo Circular 162 already concerning classifications, it could simply say, at the end of the sentence, and requires protection from unlawful discussion, comma, for the common scholars in accordance with the purposes set forth in this act. Period. Because that would already include, and, set forth in this act, comma, and under any issuance or legislation concerning the security classification of matters and information. The reason for this, Your Honor, is twofold. Number one, the Act actually discusses three things. National defense, which is the protection of national territory, critical infrastructure, and also national security, which is broadly defined already under Section 3. Second, Your Honor, MC78 actually is not limited to national defense. Anything that could be harmful to the government, regardless of whether it's national defense or security, including foreign relations information, can be classified as secret or top secret based on the gravity of its effect. And not only that, but compilations of open source data, which because of the compilation become sensitive, can also be classified. So at the same time, however, as noted by the Honorable Congressman Diokno, there is also necessary to give guidelines and limitations to the classification power of the heads of agencies. Hence, if we say, from an author's disclosure, for the purposes under this Act, or in accordance with the purposes under this Act, and other issuance or legislation concerning security classification, that would provide also the purpose of both broadening, but at the same time providing guardrails. If that would be amenable, it reconciles, Your Honor, the discussion earlier. Thank you, Your Honors.
Thank you, Attorney Silva. So, does the proponent accept?
Here we have heard all of the comments, but I believe that this definition under Section 3
Are more precise and clear and could be better understood by everyone. Those private citizens and government officials who will implement this. So therefore, I would stick with what we have right now and move for approval of Section 3 as is, Madam Chair.
So we move Section 3.
Just for the record, Madam Chair, may I just register my objection
Yes.
for the reasons stated?
Yes, of course, Kong Diokno. We will record your objections. Thank you very much. Last comment from Lieutenant Commander Ramos.
Good morning, Your Honor.
before we go to the approval of the entire section, this is technically a concern on our organization on the definition of under letter E, the definition of the national defense asset, because I think you may all know that the Coast Guard has an auxiliary, which is a volunteer civilian organization.
Correct.
And for the Coast Guard, we believe that under Section E, we are part, our bases, Coast Guard bases, our vessels are considered national defense asset. But when it comes to auxiliaries, I think we may also have preservation, Your Honor, when it comes to the assets owned by our auxiliaries, because those kind of assets are only technically being activated if we do need their help. So for the entire duration, for example, a civilian with some floating assets, those assets are not deemed part of the Coast Guard unless we ask their help. So that's technically our concern, Your Honor. Thank you.
Thank you, sir. Okay.
So you're suggesting to include here the Philippine Coast Guard, right? That is the intention. So I have no objection, Mr. Chairman, to after the Philippine National Police, Philippine Coast Guard, because they're not under the AFP, under the OTR. So I move that that will be included after Philippine National Police,
The Philippine Coast Guard. Thank you, Madam
Okay.
Chair.
Thank you very much. If there
Madam
are
Chair?
Yes.
I would like to manifest my support for the consolidated bill and
Okay.
also move for the inclusion of all members present in the consolidated as co-authors of the said.
Okay, let's approve
consolidated.
section 3 first. Can I get a motion to approve?
We would
Madam Chair.
advance also our acceptance
Subject,
to the
of course,
co-authorship.
subject to the amendments made by Lieutenant Commander Ramos.
Madam Chair, before we
Yes.
approve, regarding Section 3, letter B, instead of the word debilitating impact, can we use the term detrimental? I think that is easier to prove detrimental rather than debilitating. The term debilitating implies a functional impairment that could be difficult on the part of the prosecution to prove. So let's just use detrimental.
Yes. Accepted.
Thank you.
Madam Chair, I was wondering because the CII as the critical infrastructure as defined here is also the definition of CI in other legislations. Madam Chair, we may need to take a look at the
Okay.
impact of changing certain word from
Okay,
the
I
definition.
understand. Like this, can I just get a motion first to approve this section
Move to approve
to approve
the entire
the
section as amended.
as amended?
Second.
Okay, we approve section 3. I will welcome your suggestions for wording, for any of the provisions that you think should be edited further. We approved all sections subject to style, subject to formatting. Yes, Chair Rufus. And we will revise the draft to include your suggestions, your amendments, and the amendments made earlier.
Madam Chair.
Please reiterate your motion.
Thank you, Madam Chair. Again, I'd like to manifest my support for the consolidated bill, and I move that all members present be included as co-authors for the said bill.
Thank you, Madam Chair.
Thank you. The motion it has been laid and there is no objection and it has been seconded.
So the motion to include all members present is as co-authors is approved. And
Also, Madam Chair, I move for the approval of the consolidated bill with amendments.
yes. Okay. Second.
Subject to style.
And the same motion has been seconded. So the motion to approve the consolidated bill, subject to style, subject to amendments, has also been approved.
Madam Chair, I move that we approve the committee report. As already, we have gathered all already to fast track this. The country needs this. That the committee report with all the amendments and the suggestions incorporated, I move for approval so that we can send this already to the plenary. Thank you.
Second.
Thank you. The motion to approve.
I thought it's already the Mother Committee for submission, the report to the Commission, to the submission to the Mother Committee, the revision of laws.
Okay.
Thank you.
Okay. We will forward the subcommittee report to the Mother Committee, the Committee on Revision of Laws, and joint with the Committee on National Defense and Security. Anything else? That's all.
Thank you, Madam Chair. Motion to adjourn.
Move to adjourn.
Motion to adjourn. There's a motion
Move to adjourn.
Before that, Madam Chair, I wish to request the committee to already tackle next week the revision of the revised penal code, so that this will go hand in hand.
Yes, we have a schedule.
Thank you. So I have no more objection to the motion, the privilege motion
you,
and
Dick.
favorite motion to adjourn.
There's a motion to adjourn which has been seconded. The motion is approved. This subcommittee meeting is now adjourned. Thank you very much, everyone.